We like that.
And he says, I'm
Here's the word fast.
Okay, perfect. No, you're in the right place. Okay. did you all stay there?
So I was taking care of him. I took care of a call, whenever he was exhausted. Melissa had asked what call I made him promise that he would stay there and take care of the call and watch the case and watch everything. And he, after he passed, when he said, I was in handle him, I wasn't gonna be able to go home.
So I'm gonna just, and I'm sorry, because I gotta step out because of that officer. Go into those particular days. Just kind of tell me, obviously, she was with you, and so you know some of the facts. Is there anything that you know of that she didn't mention from that day?
Yes, I went, dropped her off, and I went to his sister's house.
Okay.
And called 911.
So you called 911 after the Dollar General?
Yes.
Okay. So that was earlier, and what did you report to 911 if you just remember from there?
The cop went out there, I told him what happened about me pushing Jeremy, about him trying to go around Billy's cheeks and out the door. And I wouldn't let him. We got him out there on the back porch and tried to calm stuff down. So we went back over there, they had 9 officers over there. And, Stan, his brother-in-law.
Okay.
And, so when me and Stan got there, when we walked inside, the music was playing so loud, I had to bend over like this to stop the boy. And he said they took my keys from me, and when they took my keys till they got the house key off, that officer told me, I went and turned off the music. The officer told me that they had to leave, and that they could not be in there other than anything. That they had to
So,
Just have
I
them
don't- I-
bring
and
them
I
on up
understand
here.
that.
Is he in there now?
Yeah, they're just going now.
And then she was walking around,
They just got everybody up.
and then she was walking around telling him, getting out of here tonight, and I'm moving in here tomorrow. Then Jeremy tried to jump onto his brother-in-law. Yeah, they backing out.
Thank you, let me go.
Let's keep
This way, y'all. All rise, please. Court's back in session.
They heard your, yes. As soon as they heard your way up, they all ran out. Probation today? I'm usually not in here. I'm usually still.
I hope they come. I got to give them my sample.
No, this is.
Afternoon, Your Honor. Frustrated. I waited an hour and a half to see Mr. Allen this morning, and they weren't able to get him out to me, so I had to meet with him 5 minutes ago. If we can call that one first, I'd appreciate it. I've got witnesses here, some of, at least one of whom's got to pick up kids later.
The other two. Bell and Crooks.
All right. Make sure we're good.
Judge, Mr. Allen is recovering from a gunshot wound. With the court's permission, I'd like to let him sit at the council table with me.
I'm fine with that.
Thank you, sir. All right, sir, come around and have a seat in this chair over here. I think you're going to find it a bit more comfortable.
Get this thing out of me.
Yes, sir.
Thank you.
All right.
All right, just to make the announcement, this is 2025 CF 724, State of Florida versus Billy Lee Allen, who is present with his lawyer, Mr. Williams. Who's handling this for the state?
Your Honor, I am Ashley Herndon on behalf of the state of Florida, and we are moving for pretrial detention in this matter.
Are you ready to go forward with that today, Mr. Williams?
Yes, Your Honor, I
I know
am.
you stated you had some issues in getting a chance to speak to Mr. Allen today. Do you need some more time before we go forward with the pretrial detention hearing?
Judge, I'm more concerned about the availability of our witnesses, and so I'd like to go ahead and proceed forward. I don't see a circumstance where Mr. Allen would be agreeing to pretrial detention, and any delay would just delay a ruling by the court.
All right, I've reviewed the motion that's been filed to the state just as a little bit of, I guess, inside baseball. I signed the warrant for the search of the house and the arrest on Saturday when I was on duty, so I'm a little familiar with the facts from reading that, just to kind of put that out there so everyone knows I've already read those things. And then obviously, I've read the motion and papers that are already in the file. But
Yes, sir.
I like to put that out there just so everyone knows that I've read things that may not be in the file, which would include those affidavits. All right, Ms. Herndon, how would you like to proceed?
Your Honor, I would call my first witness, who is going to be Melissa Anthony.
All right, Ms. Anthony? Anthony, can you raise your right? You swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Take a seat there. Speak into the microphone so we can all hear you. Okay. All right, your witnesses.
Would you please state your name for the record?
Melissa Anthony,
And Miss Anthony, where do you currently reside, just the city and state?
Crestview, Florida.
Okay. I want to turn your attention back to April 5th, which I believe was last week, involving an incident at 4228 Baton Road. Do you recognize that address?
Yes.
And what is that address?
My dad passed away. That is the home he left me.
Is that located in Crestview?
Yes.
Were you over at the residence in the evening hours on April 5th?
Yes.
Okay. And can you just tell us briefly, was there an incident involving Mr. Allen?
Yes.
Can you just kind of start with just generally, we're more concerned with the incident involving the alleged crime, but if you can start generally with the evening, why you all were over there and what happened?
We had an agreement with Billy 2 months prior that I would like him to leave. He agreed. He just had to find a place. Upon that evening, he informed us that we would have to evict him, which kind of started a trickling effect. So we started removing items from the house so we can start the whole process of selling the things and cleaning up the place. And the cops got called upon that, told us our rights. About an hour and a half after the cops left the first time, we went inside and we had our belongings in there. We gathered them, and shortly after, Jeremy walked outside, and then Billy went to his room.
So I'm going to stop you just for a second so that we're all on the same page with names. You said Jeremy. Who is Jeremy?
Jeremy is my partner, the guy that shot the gun,
And what is Jeremy's last name?
Richardson.
So you said that Jeremy went outside and that Billy went into his room.
Yes.
What happened then?
Upon exiting his room, I noticed he had a gun. I asked him to put the gun away. At that time, I had pulled out the phone to record just in case anything happened. Jeremy walked in the house and Billy entered the room that he entered and shot at him. Then followed to the door. I went into the bathroom because I had no other place to go. And then I heard shots fired.
Let me stop you there. Could you just generally describe the gun that you said Billy had?
I'm not familiar with guns.
And I mean
Just
short
a
gun,
black
long gun?
Pistol,
Okay.
black pistol.
Did he ever point the gun at you?
No.
And what room was Jeremy in? I believe you said that Jeremy walked in. I just want to make sure that I'm clear and that I followed. Where did Billy shoot at Jeremy? Where was Jeremy at that time?
The back living room?
And did you see that shot fired?
Yes.
After that shot was fired, what did you do?
I turned around and ran into the bathroom.
Do you recall how many shots were fired?
I know the one Billy shot, and then when I went in the bathroom, I heard 4 more shots.
Ms. Anthony, can you identify the individual in the courtroom that fired those shots today?
Yes.
And could you describe an article of his clothing, point to him, just generally?
Which one?
The individual that fired the gun?
Yes, he's in the brown shirt.
Your
Or
Honor,
the other one.
I'm sorry?
They're both shotguns, so I'm sorry.
I'm talking about, you described Billy as shooting a gun, correct?
Can I stop you for a minute, Ms.
Yes.
Redden? Are other witnesses in the room? Does anyone want to invoke the rule at this time?
Judge, I'm fine.
Up to y'all. Okay.
I'm sorry, just so that we're clear, can you point out to the individual Billy that you described that fired the gun?
Yeah.
Okay. Your Honor, if the record could reflect that she's identified the defendant.
Okay. The record
No
should
objection.
reflect.
Let me ask you a question, Ms. Norton. You said that, that there was another individual that fired. Were you able to see that, or is that based on what you were told?
What I was told.
Okay, so I'm not going to go into asking about that, but there were multiple gunshots fired. Was Mr. Allen also shot in this episode that you are speaking about?
I I didn't witness it with my eyes, but
Okay.
yes.
When you came out, did you come out of the bathroom at some point?
Yes.
Okay, when you came out, who was there?
I ran straight out the door that was adjacent, and I didn't look around. I just ran outside.
Did you dial 911 or contact law enforcement?
I tried. The service was bad. My daughter, she called 911 for me
Okay. And where was she located during this?
in the RV
Is
outside
that?
the home, yes.
Okay,
in
outside the
same
home.
Address.
I don't have any other questions of this witness, Your Honor.
All right, your witness, Mr. Williams.
Thank you. Ma'am, I'm sorry, what was the name of the person that you called that was in the RV?
Kalia Anthony,
Leah Anthony, and who is she?
my daughter,
How old is she?
12.
Okay. Did you call 911 at all?
I did.
All righty. Now, you said you don't really know much about guns. Let me ask you this. The gun that you say that Billy had, what color was it? Was it silver or was
Black.
it black?
Black.
Okay. Do you know the difference between a revolver and a pistol?
Yes.
All right. Was it a pistol or a revolver?
A pistol.
Okay. Did you happen to see the gun that your partner had?
No.
Have you ever seen him with a gun?
Yes.
Okay. Do you know how many guns he has?
Maybe 4, not an exact number.
Okay. Now, did you leave out any sort of physical altercation or threats that occurred earlier before the police came out?
Where Billy pulled out a knife was
Well-
the only threat.
Yeah, but let's talk about what was going on when Billy pulled out that knife, right? There'd been an argument, and Billy had said that you'd have to evict him,
Correct.
right? And you understand, now, Billy'd been living there with your father prior to your father's death, correct?
Correct.
And how long had he been living there?
10 months since my dad passed.
Okay. And there was some discussion about that Mr. Richardson would not be allowed to put hands on Billy, correct?
Correct.
And Mr. Richardson's solution to that conundrum was to threaten to and attempt to pick up the wheelchair so that he could throw the wheelchair with Billy in it out the doorway, correct?
It wasn't a wheelchair, it was a recliner, but yes.
Okay. Do you know how old Billy is?
71 is what they said, but. I
So
think
over
he's
65?
72.
Correct?
Correct.
Okay. And do you know whether or not he was in good health?
No.
Do you have any opinion? Let me ask you this. Is the house off grade?
What does that mean?
Is it up on, do you have to go up steps to get in the house?
Yes.
Okay. And how far up the steps? I mean, are they a foot off, 2 feet off, 3 feet off, what?
About 3 steps.
Okay.
High.
Do you have an opinion on whether or not that would hurt Billy to be thrown?
Improper.
I'll withdraw it, Judge.
Questions withdrawn.
So it would be fair to say that there was some demonstration of physical or threat of physical violence towards Billy made by Mr. Richardson during that earlier scene.
I wouldn't say it was a
Hold on
threat
a second.
towards Billy.
Mr. Richardson, I need you to stop shaking your head or nodding your head. I don't think you're trying to indicate an answer to the witness, but if it happens again, I'm going to have you go in the hallway. Finish your answer, ma'am.
I'm sorry, can you repeat the question?
I asked you about a threat of physical violence by Mr. Richardson towards Billy during that earlier incident.
Not towards Billy, but just removing the chair from the house.
All right, so removing the chair by throwing it out of the house with Billy in it didn't seem like a potentially violent act to you. Is that your testimony under oath today?
I guess not.
I'm sorry?
No, sir.
That's not your testimony under oath.
I guess it is violent
Okay.
towards him.
How old is Mr. Richardson?
36.
All right. So Billy's roughly twice his age, right?
Yes.
Okay. Now, do you recall anyone else showing up at the house?
When the cops came the first time, Sheila and another gentleman came. But other than that, no.
You don't recall anybody else being there?
After the cops the first time, can you be more specific?
Anybody else coming to check on Billy?
It was Sheila and the gentleman she brought with him.
Would that be Johnny Peters?
I'm not sure of his name.
Do you recall any telephone conversations taking place during the course of this initial argument?
Yes, I seen him make a phone call.
Do you know who was on the other line of that phone?
No. Maybe his sister?
I don't have any further questions at this time, Judge.
Can you redirect, Ms. Herndon?
Just briefly. Ms. Anthony, in talking about the prior incident regarding the removal of the chair, did you ever observe Mr. Richardson touch Billy Allen?
No, ma'am.
Did he physically move that chair from its location with Mr. Allen in it?
No.
Those are my questions.
All right. Ma'am, you can take your seat back out in the audience. Thank you. Next witness, Ms. Herndon.
Your Honor, next we would call Jeremy Richardson.
All right, Mr. Richardson. Or do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Take a seat. Make sure you speak into the microphone. Go ahead, ma'am.
Would you please state your name for the record?
Jeremy Richardson,
And where do you currently reside, Mr. Richardson?
152 Palmetto Drive, Crestview, Florida.
I want to turn your attention back to April 5th. Were you over at a residence that is located in Crestview, in Crestview at 4228 Baton Road?
Yes, ma'am.
And who were you at that residence with on April 5th?
With my partner, Melissa Anthony.
Was there anyone else that was with you going to that residence?
Kalia Anthony.
And who is that?
That's my partner's daughter.
How old is she?
She's 12.
During the, late afternoon hours on that date, was there an incident involving you and Billy Allen in the house? And I'm going to just start at the beginning and go kind of contemporaneously through. Was there an incident earlier in the evening with Mr. Allen?
Yes, ma'am.
And what was that about?
It was for him to be evicted.
During that incident, Obviously, you have heard what was testified to. Did you make any threats to Mr. Allen about removing him from the house?
I did not to him. I said the chair.
Did you physically move the chair from the location it was at?
No, ma'am.
Did you put your hands on Mr. Allen?
No, ma'am.
During that incident, did you observe any reaction from Mr. Allen to that statement about you removing the chair?
He pulled a knife.
Where did he pull the knife from?
I believe the dresser or nightstand table that was beside him.
What did you do after that?
I stayed back and started to argue with him.
After this argument, was law enforcement called or did they arrive on the scene?
Yes, ma'am.
Was anything done regarding anybody being removed from the house, anybody arrested at that time?
No, ma'am.
After they left, at some point, did the situation change?
What do you mean by change?
After law enforcement left, did you and, let me strike that, did you and Melissa remain at the residence?
Yes, ma'am.
Okay. During the course of the nighttime hours, was there another incident with Billy Allen?
Yes, ma'am, later on.
Okay, and what happened during that incident later on?
That was, like that was described earlier, he ended up pulling a gun and firing it at me.
So I want to kind of walk you through the exact sequence of events that occurred. Where were you when this happened? When he pulled the gun?
I was coming in the back door.
And where was Mr. Allen?
He was in the living room.
Okay. Were you able to see him directly?
When I came around the corner, yes.
Okay. And what did you see when you came around the corner?
He had a gun about head level, pointing it, waiting for, seemed like for me to come through the doorway.
What happened then?
When I entered the back room, or the room, he ended up pointing it at me, and I ran.
Were you afraid when he pointed the gun?
Yes, ma'am, for my life.
What happened next?
He then tried to chase me out the back door. As soon as I got out the back door and he come around the corner, he fired a shot.
Do you recall how many shots were fired? Was it one?
The first one was one, yes.
Okay. What happened then?
I was running and ended up, I stopped because I didn't want him to come back through, and there was a window there that he could see out. So I kept running. I looked back and he was pointing the weapon out the back door. And that's when I fired rounds, because if I didn't, he was going to shoot me and kill me.
So let me ask you specifically about that. Did you have a gun when you initially went into the house that second time?
Yes, ma'am.
On your person?
Yes, ma'am. It was in my pocket.
Why did you have a gun in your pocket?
I feared for my life.
Where did that gun come from?
It came out of my truck.
And when did you retrieve it from your truck?
When I had went outside earlier.
Earlier, meaning when the police were there? When did you retrieve it?
After they had left, I went out to the truck, and when I came back, I had it in my pocket.
How many total shots did Mr. Allen fire at you?
I believe it was upwards of 2 or more.
Okay. And at what point did you fire your firearm?
After the first round, and I saw the gun poking out while I was running away.
And did you shoot Mr. Allen?
I didn't know at the time, no.
How many shots did you fire?
I fired 4.
Let me ask you, where was Miss Anthony during this?
Trapped in the bathroom.
Did you ever see Mr. Allen point the gun at Miss Anthony?
No, ma'am.
Those are my questions for Mr. Richardson.
Mr. Williams-Cross?
Yes, Your Honor. Sir, what is your middle name?
Charles,
And what is your date of birth?
5/10/89.
Now, you indicated that you didn't touch Mr. Allen.
No, sir.
He was sitting in a chair.
Yes, sir.
And isn't it a fact that when you were told that you could not touch him, that's when you suggested that you just pick up the chair that he's in, and that way you wouldn't be touching him, you'd just be throwing the chair with him in it out the door?
I didn't threaten to throw it out with him. I said, take it out the room.
Had you been told at that point that you'd have to go through an eviction process, or actually not you, but rather the previous witness?
The cops hadn't been there yet before that.
Now, you indicated that he was standing in the doorway and that you were outside and that you fired shots to protect yourself.
Yes, sir.
And so he was facing you with a gun when you fired those shots, correct?
Yes, sir.
Do you know where your bullet wound up?
No, sir.
And what kind of gun were you using?
A .38 special.
Revolver?
Yes, sir.
What kind of rounds did you have in it? 38 plus Ps? What?
It was a .38 hollow point special.
Had you made any other threats towards Mr. Allen that night prior to, well, let me ask you this first. When you made the initial comment about throwing the chair or taking the chair out with him in it, did you have the gun on you then?
No, sir.
Did you have the gun on you when law enforcement showed up the first time?
No, sir.
So you armed yourself after y'all had been told that you'd have to go through an eviction process.
Yes, sir.
Was it your intention when you armed yourself to threaten or intimidate Mr. Allen to keep you from having to go through the eviction process?
No, sir. It's for my protection and my family's.
Now, when you initially took the stand, you said that you were there to evict him. You did not have an order of eviction from a judge, did you?
No, but we had been there, had already gave a warning 2 months, and then he said that.
Okay, and so you were of the opinion that as long as you, quote, warned him that you didn't have to get an order of eviction if he chose to stay.
No, sir.
You could just pick him up and put him out.
No, sir. That was my partner's furniture is why I was trying to get the furniture out. But the eviction, we knew that we would have to go through the process.
Now, how tall are you and how much do you weigh?
I'm 5'10" and 180 pounds.
And you acknowledge that you're half the age of
Yes,
this
sir.
gentleman. And it's your testimony here today that you're afraid of him.
Yes, sir.
I don't have anything further, Judge.
Any redirect? All right, you can take your seat, sir. Thank you. Other witnesses?
Those are the state's witnesses.
Mr. Williams?
Yes, Judge. Let me first call Sheila Hahn.
What's the last name?
I believe it's Hahn. I'll get her to spell it when she... Gets on the stand, Judge.
Ma'am, can you raise your right hand? You swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Take a seat there, please. Make sure you speak into that microphone for us. Your witness, Mr. Williams.
Thank you. Ma'am, would you please state your name for the record and spell both your first and your last name? I have a friend that used to spell hers Shelia.
Okay, it's Sheila and Hahn, Hahn.
All righty. Ms. Hahn, let me ask you something. Do you know Billy Allen?
Yes, I do.
Okay. And how long have you known Mr. Allen?
All my life.
All righty. Do you find Mr. Allen to be a violent, dangerous person?
No.
Objection. Etiquette.
Well, Judge, she testified that she'd known him all her life.
And then you're going into character evidence.
Well, I'll wait until we get to the question of bond if the court doesn't impose PTD, and then I'll ask her again.
Assisting.
All right. Were you present for any of the events that occurred back on the 5th?
I was for the 4th, yes.
Or the 4th, rather. All right, so tell us how you got involved and what you saw and heard.
I also lived there with Billy. I took care of Billy. Melissa had asked me to move in there to do that. I had went over there to check on Billy because I was unable to get in contact with him by phone.
Let me interrupt you for a second. Why do you said Melissa had asked you to look after Billy. Why does Billy need you to look after him?
He has heart problems, and I've had to pick him up. His oxygen level goes down. She's been with me when I've called the ambulance to come get him. And I've also been by myself when I've had to call the ambulance to come get him because of his oxygen level dropping.
Okay. All right. So you described that you had not heard or seen him in 3 days or so?
Yes, sir.
All right. So what happened when you got over to that location?
When I got over there, Jeremy comes running in the door. He brings in Melissa's daughter to sit on the couch. And he starts hollering at me, "Where the fuck is Paul's clothes at?" I said, "Melissa told me to get rid of them." "No fuck she didn't, you lying bitch. I'm pissing go get her." Out the door he went to go get Melissa. Melissa comes in. And then Melissa said, "Yes, I did." And then he's like, "Where's his tools out?" I said, "Why don't you look in the box that's in the closet?" And he said, "Oh, well, where's the rest of the stuff?" I said, "Melissa, me and Billy, after Paul passed, Melissa was in there with me, and we filled up 3 black garbage bags of his medicine and dumping it out and everything else that Melissa had told us to get rid of out of that room." And then we walked out, and Melissa was like, "Well, what the fuck are you even doing here?" I said, "I come out here to see Billy, and my stuff is still here." You know? I said, "You ain't never had enough problem with me coming before." And, well, I want him to fuck up out of here. And Billy said, "Evict me." And that's gonna cost me more money, da-da-da. And Jeremy went to go, he said, Melissa was like, "You leaving here tonight one way or another, dead or alive. I don't give a fuck. I hope you fucking have a heart attack. You son of a bitch." And then Jeremy ran up there, grabbed the
I'll
chair.
interrupt you for just a second. As part of his care, are you familiar with his medical status?
Yes, I am.
Does he have a history of cardiac problems?
Yes, he does.
Okay, go ahead, ma'am. I'm sorry to interrupt.
So anyways, Jeremy bent down to pick up the chair, and he moved it. And then
Where was Mr. Allen when he picked up the chair and moved it?
sitting there in the chair,
Same chair?
the same chair, he had the knife in his hand. He told Jeremy, "Do not touch me." And Jeremy's like, "I'm gonna take you and the 2 dogs and shove y'all out the fucking door. Is where you fucking going, out there in the fucking yard."
Okay, go ahead, ma'am.
And then after that, I got in between him. I started pushing Jeremy. I said, Jeremy, you're not putting your hands on him. Leave him the fuck alone. Just go. Just go. And I just kept pushing him. And then he was like, no, he's going around me trying to grab the chair, the back of the chair. And I pushed him again. He stopped, pushed him into the dining area. He stood there. Melissa told him to walk outside. And
Now, did Jeremy say anything about getting around this don't touch him instruction and how the chair fit into that? The look of confusion tells me that if he did, you don't remember it. Okay.
no, I don't understand your question.
Oh, okay. Did he say anything about how, why he was going to pick the chair up and move the chair with Billy in it?
Because Billy was leaving there that night, whether he wanted to or not, one way or another.
All right. So tell the court what else you saw and heard.
Okay, so we went outside, we tried to talk to him, calm him down
Tried to
and
talk to
everything. And then,
Trying to talk to who, ma'am?
Melissa and Jeremy.
Okay.
You know, put some sense in their head, you know, he's 73, you know, you can't be doing that, you know? Then me and Miss Long left, and me and Stan Peters, his brother-in-law, came back with the law there. The law had told them, because when we came in, Melissa was running around saying, you motherfucker, I'm gonna play nigger music till it runs you fucking crazy tonight. Y'all, you gonna be living, you gonna be laying your ass in there on the floor, because we taking out all the furniture. I'm gonna be moving in here tomorrow. I'm changing my address to this address and everything. And the law was out there, and the law walked in. I had turned off the music. And the law said, no, the music cannot be playing that loud, and y'all have got to go. Y'all not allowed in this house. Y'all not allowed to remove anything from this house. I'm telling you now, y'all got to go. Y'all got to get an eviction notice.
Okay, now when the officer's saying y'all, who is he talking to?
Melissa and Jeremy.
Okay.
And that they was not allowed to take nothing else out of that house till they went and got an eviction notice on him.
All right, did anybody say anything about probate?
No, I never heard nothing about probate.
Anybody say anything about a personal representative or an inventory of the contents or anything like
No.
that? Okay.
She had wanted us to get rid of everything in the house. And, you know, Paul had just passed, and, you know, it even took me a while to get rid of his clothes because, you know, he was my boyfriend.
That's at this point.
So,
Okay, where are we going with this part of it, Mr. Williams?
I'm going to see if I can't get us in for a landing judge. Did you see or hear any other acts or threats of violence until the point when you left?
Melissa was outside because they had the table moved out there. And they had also taken Billy's keys from him and would not let him have them until they took the house key off. And they had given them back to him after that. And then the law was still there. Melissa was out there banging her beer on the table going, I'm going to stay out here and raise hell all night long, and I hope the fuck he has a heart attack, but he is leaving here tonight, dead or alive.
All right. Let me ask you, this Mr. Peters that was there with you,
Yes,
have you ever seen his handwriting before?
yes, sir.
In fact, did he go with you to the public defender's office and provide a statement?
Yes, sir.
Okay. I provided a copy to the state earlier. Let me show you what I'm going to mark as D1. This has got my highlighting, and as usual, I've highlighted just about everything. But is that Mr. Peters' handwriting?
Yes,
Do you recall him being with him when he wrote that statement?
yes, sir.
Okay. Judge, this is a preliminary hearing, so hearsay is admissible. I provided a copy.
And proper foundation, I don't think the issue is hearsay, but I don't believe that this witness can properly authenticate a document signed by another.
It is notarized.
Then it may be admissible on other grounds. I don't think it comes in through this witness.
I know what Jeremy done.
Ma'am,
Oh.
this is a legal argument right now.
Well, Judge,
I have to review it to see what it is,
however
obviously.
it comes in.
All right. I think this is probably a good time to point out the fact that we're kind of in a transition of how the rule for pretrial detention is changing. The Supreme Court changed that rule about a week ago, but it hasn't. Those changes have not yet come into play. They don't come into play until May 1st. So, based on the current rule of 3.132. C1 states the court may admit relevant evidence and testimony under oath without complying with the rules of evidence. But evidence secured in violation of the United States Constitution or the Constitution of the State of Florida shall not be admissible. A final order of pretrial detention shall not be based exclusively on hearsay. So I understand the state's objection. I think given the rules that are in play as of right now, that I can admit this. It is as far as, well, hold on a second. Yeah, it says under penalties of perjury, I declare that I've read the foregoing statement and the facts stated in it are true. It's signed Johnny Peters and is notarized on April 9th. So I'll admit it into evidence and give it the proper weight.
Thank you, Judge.
You can give me 1 second to read it. All right. I'll point out, I've read this statement. Most of it is about what Mr. Peters says he observed of Mr. Allen when he arrived and some statements that Mr. Allen had testified to as far as what happened.
Yes, sir.
So it's kind of double hearsay at this point. But again, the rules of evidence don't exactly apply in these circumstances. That is defendant's one.
All right. Ma'am, when in all of this did you and Mr. Peters leave?
The law was backing out, and we was headed out the door to his car. And at that point in time, Jeremy went to go jump onto him.
Jeremy went to go jump
Onto Mr. Peters, yes.
Mr. Peters.
Yes.
Okay. And when you say jump on, what do you mean? Can you be more specific?
Melissa was over there telling me that she was gonna, if I went back over there, I was gonna get my ass kicked because that motherfucker went over there and tried to have her old man arrested. By telling them about, that he went after Billy.
Are you talking about the incident with the chair?
With the chair thing, yes.
Okay.
Because he had told the law about that, and the law said, well, they have been told they're not allowed back in here. They have to leave, and they're not allowed to take nothing else out of this house.
All right. And so when he was, the way you phrased it was jumping on, was he threatening Mr. Peters with
Yes.
violence?
Yes.
Okay, can
He
you
was
tell?
gonna whoop his ass.
Okay, all right. So at that point, did you guys leave?
Yes, I told Stan to get in the car, and, but Melissa and Jeremy were standing beside one another, and that's when Jeremy was like, just wait till the law leaves, wait till everybody gets out of here, we got our plans.
Okay. Other than during the physical altercation, having a knife in his hand, did you see or hear Billy threaten anybody?
No, he just said, don't touch me.
Okay. All right, I don't have anything further of this witness, Judge.
Ross?
Just very briefly. Ms. Hahn, did you read this statement filled out by Johnny Peters?
No,
Surprise you, it doesn't say anything about him being jumped on by Jeremy Richardson in it?
I said that he went to go jump onto him.
He went to, or
Yes.
did?
No, he went to.
Was there any physical contact between Jeremy Richardson and Mr. Peters?
No, I told
Okay.
Stan to get in the car,
Okay.
but he was threatening
So,
him,
Ms.
yes.
Hahn, let me just stop you. I'm going to make this real brief. So, when the police were out there and you were present, at no time did the police arrest Miss Anthony or Mr. Richardson?
No, they told them to leave.
So, no one was arrested
No.
at that time? I don't have anything further.
Any redirect, Mr. Williams?
No, Your Honor.
All right, you can take your seat, ma'am. Any other witnesses?
Yes, Your Honor. I'll call Loretta Long.
Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth?
I do.
There, make sure you speak into the microphone. You're a witness.
Thank you, Judge. Ma'am, please state your name for the record.
Loretta Long.
Ms. Long, what's your relationship to Mr. Allen?
I've known Billy for a long time. We didn't really have a relationship. I would just see him every now and then.
Okay. Did you go out to the address that we've been talking about on the 4th?
I did go to an address with Sheila to check on Billy because she asked me to ride with her, yes.
Okay. And tell us what you saw and observed while you were there.
We went in, and as soon as we got in, Jeremy came in, and he went to a room to the left of the living room. And he got upset because clothes were missing. And he accused Sheila and them and Billy of stealing Paul's clothes. And Sheila told him that Melissa had told her to get rid of them. And he came in with a child, a 10, 11, 12-year-old child. I don't know how old the child was. It was Melissa's daughter. And then he left and went outside, and Melissa came back in with him. And they went into the room. Sheila went into the room. And Melissa told Jeremy that she had told them to get rid of the clothes.
Now, is this something that you were able to overhear?
Absolutely.
Okay.
And then he asked, where was the tools? And Sheila said, in that box. I don't know what they were talking about. I couldn't see. I could only hear. And he was changing a doorknob. I could tell that's what he was doing to that room door.
What seemed to be his state of mind? Mr. Richardson.
Mr. Richards was drinking.
Okay. And did he seem to be calm, or did he seem to be upset?
He was definitely upset.
Okay. Did you see any sort, or was there any discussion about removing Mr. Allen?
Absolutely.
All right, so tell the court about that.
When the conference, whatever was going on in that room, Melissa came out and she told Billy that she wanted him to get out of the house, but in a lot more colorful language. And Billy told her she would have to evict him. And she got really upset. She was just drinking too. I could smell alcohol on both of them. And then Jeremy got upset because he thought Billy had disrespected Melissa. And he came out and addressed that. And he was angry.
When you say address that, did he say?
He said, you will not disrespect my wife.
Okay.
Or girlfriend, or whatever they are. I don't know them.
All righty. And what happened then?
He told Billy he was gonna pick his old ass up and move him out, throw him out that front door, and Billy said, "You better not touch me."
All right, and how did Mr. Richardson respond?
He said, "I'm not gonna touch you, I'm gonna throw the chair out with you and them damn dogs in it, right out that front door into the yard."
All righty. So what happened then?
He walked over to the chair, and he lifted the chair, and he kinda moved it. He definitely moved the chair, not very far, but he picked it up and moved it, and then Billy pulled a knife.
And what happened at that point?
Somebody said he's got a knife, and then it just sort of stopped. And Sheila was shoving Jeremy to move away from Billy and the chair. And then it sort of escalated with Jeremy. I don't know if escalate's the right word, but he went into the dining room, and Melissa asked him to go out on the porch.
All right, and did he leave the house?
He did.
Okay. Did you
Well, he
see-
left the inside of the house.
Right, that's what I mean.
Yes.
Did you see where he went?
To another room and out a door.
Okay, did you see, though, once he stepped outside, where he went from there?
He stayed on the porch.
Okay. So he did not go to a car at that point?
No, sir.
All righty. Did you ever see him go to his car?
No.
Okay. So, did you leave when Sheila left?
Oh, yes, I rode with her.
Okay. So up until that point, you didn't see him go to the car where he could have obtained a gun?
Objection leading.
Clean it up, Mr. Williams.
All right. So up until that point, you didn't see him go to his car?
No.
Okay. Now, I think you already told us that you didn't know them.
Correct.
Did you, at any point during this, see Mr. Allen act threatening, other than after the incident with the chair, having a knife, threaten anybody, pull a weapon, pull a gun, anything like that?
And no, I never saw any of that.
Okay.
He never got out of the chair, ever, when I was there.
All right, I don't have anything further, Judge.
Cross, Ms. Herndon.
Just briefly. Ms. Long, what time of day was this that you were there?
It was on the 4th, on Friday, April the 4th, and it was around, I don't know really what exact time it was, but it was before dark, and we were there approximately, well, it was after dark when we left. It wasn't very long we were there.
Okay.
It occurred very rapidly and very quickly.
Okay, so would you approximate you were there less than an hour?
An hour, hour and a half, I don't really know. I can't answer that question for sure.
Okay. You were not there when law enforcement came?
No, ma'am. On the 4th, I left and went home, and everything else that occurred, I have no knowledge.
Okay, those are my questions.
Redirect.
No redirect, Your Honor.
Thank you.
Any other witnesses?
No, Your Honor.
Any rebuttal, Ms. Herndon?
No, Your Honor.
All right, argument from the state.
Your Honor, right now, Mr. Allen has been charged with count of aggravated assault with a firearm and possession of a firearm by a convicted felon. I anticipate that once charges are formally filed, that the possession of a firearm by a felon will be filed under 1020 life, including a discharge, which would be a 20-year minimum mandatory sentence. You've heard the testimony from Ms. Anthony and Mr. Richardson. Obviously, this started as a landlord-tenant issue. There were some arguments earlier in the day. Law enforcement came out. No one was arrested at that time. Some period of time goes by, and later on in the evening, when they are at the house, Miss Anthony testified that she saw Mr. Allen with a gun. Mr. Richardson comes back from outside around the corner, sees Mr. Allen holding a gun pointed at his head, takes off to run. Mr. Allen fires a shot, and Mr. Richardson fires back, ultimately shooting Mr. Richardson. shooting Mr. Allen. Your Honor, this is a dangerous crime pursuant to Florida statutes. Based on the facts and circumstances of this situation, it is the state's position that Mr. Allen should be detained, that there are no reasonable circumstances that would be able to prevent a danger to the community. Mr. Allen has a significant felony record back from the 70s and 80s, including violent offenses. It appears that the most recent felony conviction that he had was from approximately 1984 involving resisting with violence. But based on the escalation and the testimony regarding a knife being pulled by Mr. Allen, the shots fired, this is certainly a situation where the individuals could have been killed, and we are asking the court to detain Mr. Allen with no bond.
Mr. Williams.
Judge, the standard is whether they're charged with a dangerous crime, whether there's a substantial probability that the defendant committed such crime, and whether the factual circumstances of the crime indicate a disregard for the safety of the community, and that there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. Now, Judge, what I will say initially is the state brought up that they're likely to seek a 20-year mandatory minimum in the case. Judge, I don't know if that's relevant to the charge or relevant to any of these conditions. What it might be relevant to is whether or not he would have an incentive to flee the jurisdiction of the court, but I don't think we're there yet. And I have information that I'll provide that would suggest that he's not a flight risk in this case. In terms of the factual circumstances, the factual circumstances are that an individual half his age threatened to throw him in the chair that he was in out the door because he had been drinking and was upset at the fact that he was going to have to, comply with the eviction process, which is the law. Even if he'd said he was going to leave, and there's been no corroboration of that, but even if he had told them earlier that he was going to leave, he could at any point say, you know what, no, go ahead and file for eviction. In terms of whether or not there are conditions of release reasonably sufficient to protect the community, he's ambulatory with a walker, Judge. He was the only individual who was shot that night. He's presented here in court with a walker. The state brings out that he had some, quote, violent offenses in the 70s and 80s without any specificity other than a 1984 arrest for resisting arrest without violence. And in 1984, you could pick up a with violence by jerking your hands away from the handcuffs. When the court listens to all the testimony, the only people that were saying anything violent from the beginning were the alleged victims in this case. Mr. Richardson testified that he left and went to go get a gun from the car. Nobody saw him do that. It may be that he did that after Sheila and them had left, but this is a situation with a 72-year-old man who has responded to repeated threats that to a 35-year-old man in good health, that may not seem like very much. Having somebody pick up a chair and toss you out a door may not seem that threatening, but to a 72-year-old heart patient, that's a problem. Somebody who has someone who testified unrebutted that they look after him because his oxygen gets low and he passes out. So, Judge, pretrial detention is not an appropriate response in this case. We're going to ask the court to allow us to have a bond.
Ms. Herndon, anything else?
Your Honor, I think the facts are pretty clear. Individual that shoots at two individuals that are the lawful homeowners of the house, whether there's an eviction process or not, there is no process that allows you to shoot at people. And based on that, we believe that he is absolutely a danger to the community. It is a dangerous offense. There's substantial evidence.
All right. Again, I've said it earlier, but it kind of bears repeating that we're kind of in this no man's land between the changes in the rule, where the rule that's currently exists, 3.132, regarding pretrial detention, doesn't exactly jive with the current statute, which is 907.041, as far as what the particular burden is. But I think the statute states that 907.041. Sure I'm getting the right subparagraph. It's 1C. States upon motion by the state attorney, which the state has done in this particular case, the court may order pretrial detention if it finds a substantial probability based on the defendant's past and present patterns of behavior, criteria 903.046, and the relevant factors that any of the following exist. Based on the language that was used by Ms. Herndon during the argument, it would appear that C5 is what the state is particularly arguing, which is, as stated, the defendant poses the threat of harm to the community. The court may so conclude if it finds that the defendant is presently charged with a dangerous crime. Aggravated assault is such a dangerous crime under the statute. That there is a substantial probability that the defendant committed such crime. That the factual circumstances of the crime indicate a disregard for the safety of the community. And that there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. As far as the facts as I found them to be, there was some argument between the parties. Law enforcement was called. Some people left, at which point there seemingly was a second incident which involved uncontradicted testimony that Mr. Allen fired a firearm at Mr. Richardson. The testimony by Mr. Richardson was that he was basically walking into the back living room of the home, at which point he saw the gun leveled off at his head. He tried to quickly retreat, at which point he was shot at, and then a second shot was fired from the back door at Mr. Richardson as he was running away. That's not a circumstance where I believe someone is necessarily defending themselves about a situation that happened sometime earlier with intervening law enforcement intervention, I guess is the best way to use that. I used the word twice. This is not a situation where this is all some heated moment that happened over a minute or two. Law enforcement intervened and told people, kind of what they thought was the situation. I haven't heard anything about, what the current status of any probate proceeding or who actually owns the house at this point, other than Mr. Allen lived there. And it seems to be clear that Miss Anthony has some legal ownership rights to that particular home. Whether or not he was being evicted improperly is not something that allows for the use of deadly force. So I believe there is a substantial probability that Mr. Allen has committed the offense for which he's charged currently, which is aggravated assault with a firearm. I also, to point out, well, let's go through the rest of this. The factual circumstances of the crime indicate a disregard for the safety of the community. I would point out that the community doesn't mean necessarily the community as a whole, but people in that community, which can include just the people involved. Mr. Allen is charged with, and I heard evidence today that he fired a gun at Mr. Richardson. I'd also point out that during the course of this incident, other people were involved. We've all seen, unfortunately, the somewhat innocent bystanders of gun violence that often happens in these types of situations, and point out the fact there was testimony about a 12-year-old girl being present in the area when gunshots were being fired out from the door of the home into the yard where she may have still been. So that's certainly a concern about the safety or disregard for the safety of the community. Even if there was some reason that Mr. Allen would have had at that point, again, based on only the facts that I've heard here today, to fire the first shot after Mr. Richardson runs out the door and there's a fire at his back, into the open space where a 12-year-old had been at some point during the night, I think is a complete disregard for the safety of the community. And as far as conditions of release reasonably sufficient to protect the community from the risk of the physical harm to persons, I'd like to point out that Mr. Allen is currently charged with possession of a firearm by a convicted felon, meaning he should have never had the gun in the first place. If there's already a law saying that you can't have a firearm and then you allegedly use one to fire indiscriminately at somebody as they run away from you, I certainly don't see what conditions I could put into place that would make this a safe situation. So based on that, I'm going to find the state has met their burden for pretrial detention. Mr. Allen will be held in pretrial detention until further order of the court. Obviously, as the rule changes on May 1st, you can certainly ask the court to reconsider that if there's a change in the facts and circumstances that led to this pretrial detention order, but that's the rule of the court at this time. Anything else for Mr. Allen?
Not from the defense, Your Honor.
I'll have the order to you shortly. Thank you, Mr. Allen.
All right, Mr. Allen, I'll come out again and try to see you, okay?
What case do we have next?
Judge, I'm ready on either of the other two.
Is there a motion filed on both or just on Bell?
Only on Bell, Your Honor, and we do have witnesses present on that.
I'd like to take care of that so we're not having witnesses sit here for 3 or 4 hours like we did relatively recently. Bell, please. All right. Is everyone ready on Bell?
Yes, Your Honor.
All right, Ms.
Yes, Your Honor.
All right, so Mr. Bell is here on 2 separate cases. That's 25 CF 699, where he was arrested for trafficking in fentanyl, possession of a weapon or ammunition by a convicted felon, possession of narcotic equipment, and use or display of a weapon during a felony. And the second case, I don't believe is here for pretrial detention. It's aggravated stalking, although is that on, are you seeking it in that case as well? I didn't see a motion, Ms. Herndon.
Your Honor, and I'm just looking at Ms. Leone's. I think that it was under both, but honestly, the state intends to call Officer Jonathan Norton. The victim is present in court, but we're going to proceed with Officer Norton.
Okay, aggravated stalking is listed under 907-041. 5A17, so it is under both particular cases.
Judge, if I may, the motion does have both case numbers on it, but paragraph 3 alleges that in the aggravated stalking that he's charged with attempted premeditated murder, and I don't see that. I just see the aggravated stalking. I don't know the state's. When I looked at the clerk's file yesterday, don't believe the state had filed an information.
I anticipate that's a scrivener's error based on my review.
All right, so I'm looking at the motion. It says the defendant is currently charged with attempted premeditated murder, aggravated stalking by credible threat and use of two-way communication device to facilitate a felony in 25 CF 698. It's a rather large one, but the attempted premeditated murder is a scrivener's error.
Yes, Your Honor.
Okay. So we're all clear that that's not being charged, or at least hasn't been charged at this point. I don't know anything really about the facts of Mr. Bell's case.
Thank you, Judge.
All right.
Your Honor, we're ready to proceed with Officer Norton.
Okay. How many witnesses do y'all have?
I anticipate just calling Officer
Mr. Williams, do you have any witnesses here?
No, Your Honor.
Okay. Officer Norton. Was she on the docket? You raise your right hand, sir. You swear or affirm that the testimony you're about to give is the truth? Nothing but the truth. Yes. All right, take a seat there. Make sure you speak into the microphone for us.
Yes, sir.
All right, go ahead with your questions.
Would you please state your name for the record?
Officer Jonathan Norton,
Who are you currently employed with, officer?
Crestview Police Department,
And how long have you been so employed?
approximately 1 year.
I'd like to turn your attention back to April 5th. Did you have contact with a woman by the name of Kirsten Grice?
Yes, ma'am.
And what was that contact regarding?
Messages between herself and her ex-boyfriend, the defendant, Mr. Bell. She was concerned about some of the messages that he had been sending her over the course of approximately 4 days. They've been kind of escalating during that time frame, becoming a little bit more frequent and threatening in nature, and she was concerned for her safety. I had spoken with her. She had mentioned that she wasn't able to go home, and she was kind of scared for her life. So I made contact as soon as I got on shift, and I was able to, and I reviewed some of the messages.
Did she provide those to you from her cellular phone?
Yes, ma'am.
And in your review of the messages, what did you note?
I just noted that in the very beginning, when she first had trespassed him from the property, and asked law enforcement to intervene to try to remove him from the home and verify that he wasn't in the home, right when that happened, he started messaging her approximately 5-10 times, long paragraph messages. Very long messages. I can't recall off the top of my head some of the earlier ones, but she was just consistent in her replies, please stop messaging me, please stop messaging me. And as the days kind of continued on, they were throughout the evening, throughout the nighttime, kind of suggestive in nature. Whenever she would leave the home, he would, where are you going? I know where you're going. And some of them were threatening in nature, mentioning, I believe, one of the sections I quoted him on was that he was going to murk her.
Judge, I'm going to object to conclusory testimony. I mean, he's basically drawing conclusions about what he saw, but he's not actually providing the court with the evidence, what the message is.
Are you presenting the text messages? Or?
Your Honor, not at this point. We don't have the ability to, they're in the process of being transferred, but I was not able to get those downloaded for the court today.
Okay.
I apologize.
Let's keep it to anything that's
Sure.
actually a quote as opposed to
Sure.
where he paraphrases it to me.
And let me ask you, Officer Norton, during your conversation with Ms. Grice, was there a concern regarding the defendant showing up at her residence when she was not there?
Absolutely. She was concerned, I believe at the time she had mentioned that she couldn't locate her additional house key, and some of the property on her property had been moved. Specifically, there was a chair that was moved from the front yard into the dark, bushy section of the backyard, and I believe that he had mentioned that something along the chair. They had a conversation regarding the chair. So she was very concerned that he was visiting the home while she wasn't there, and it kind of made her to the point where she didn't want to return to the home.
Do you recall approximately in this 4 to 5 day period that these text messages were taking place, approximately how many messages the defendant sent Ms. Grice?
In excess of 80.
In those messages, did you see confirmation from Ms. Grice where she asked him not to contact her?
Yes.
Did the contact continue after that point?
Yes.
Did Ms. Grice relay to you how she felt about receiving these messages?
Yes, ma'am. She was in extraordinary fear. She'd mentioned she'd left her child with a family friend because she was concerned for having her child around her safely. I'd forwarded her to our victim advocate, and I was trying to find every resource that I could to assist her.
Okay. Let me ask you, Officer, based on your investigation regarding Ms. Grice's statements, did you go to make follow-up or have contact with the defendant in this matter?
I attempted to locate Mr. Bell a couple times prior to the realization of these current charges. I had been trying to make contact with him regarding some of the circumstances regarding the trespass. After she had brought these concerns up and I reviewed the information, I attempted to canvass the surrounding areas where she mentioned he had been known to frequent to attempt to interview him and talk with him in regards to this.
At some point, were you able to locate him?
Yes, ma'am.
And can you tell us just briefly what happened in that interaction?
Yes, ma'am. Upon locating him, I got out of my Crestview-issued patrol vehicle, dressed in exactly what I'm wearing today. I confirmed his identity by calling out, "Hey, Azaria Bell, I had to ask you a couple quick questions." He turned around. We spoke briefly regarding some of the issues regarding the trespass. At that point, once I had confirmed his identity and I knew that it was him, I asked him if he had any weapons on his person, based solely off of some of the statements that the victim had made in her initial affidavit of complaint, some of the firearms that he had on his person, and he had a backpack on him. He didn't want to answer. I requested him to take his back.
I'm going to object to move to strike any refusal to answer questions. He's not required to answer any questions of law enforcement.
Did you ask him to remove the
Hold on
backpack?
just a second. Sustained and struck. Go ahead.
Officer Norton, did you ask him to remove the backpack from his person?
Yes, ma'am.
At some point, did he comply?
No, ma'am.
What happened next?
When he refused to remove the backpack, myself and Corporal Sprague, we attempted to restrain his hand movements by grabbing a hold of his wrist and utilizing a custodial grasp, and I did inform Mr. Bell that he was being detained and that we could discuss some of the questions that he had as soon as I had him secured. He did brace his body against myself. He pulled frequently. He didn't want to comply with my lawful orders at that time. As we got his hands behind his back, we did pull the backpack off, and I secured it with myself. So we relocated back towards my patrol vehicle due to the large crowd that was gathering. We had him secured in the back of my patrol vehicle.
Okay. At some point during this detention, did you look inside the backpack that was on him?
Yes, ma'am. I searched his
Objection,
person.
it's not been established that it's a lawful search.
Certainly, we can.
I think evidence that was obtained in violation of the Constitution is specifically talked about that. I'm not making a ruling that it has been, but I think a predicate has to be laid.
So let me ask you, I believe you stated that you placed him in the back of the patrol car?
Yes, ma'am. So prior to placing him in the back of the patrol car, because he was being placed under arrest at that time, I conducted a search incident to arrest.
What was he being arrested for?
He was being arrested for the aggravated stalking as well as the use of a two-way communication device to facilitate a felony.
And after he was placed under arrest, you said that you searched incident to arrest. Well, let me start with him. Did you search his person?
Yes, ma'am. Prior to searching his backpack, I conducted a search of his person.
What, if anything, did you discover?
On his person, I found a blue Apple cell phone as well as a small plastic baggie containing a white powdery substance consistent with drug paraphernalia.
Did you field test that substance?
Not that substance, ma'am.
Okay. Did you find anything else?
Yes, ma'am. Once we searched his backpack, we found...
Judge, I'm going to object. It's not been established that's even a valid search incident to arrest. He testified where he placed the backpack, but nobody's testified as to whether or not he was in a position where he could still obtain a weapon or easily destroyable evidence from the backpack. At that point,
Let me just stop you, Mr. Williams. If you want to argue further, but from what I heard the testimony to be, he was being arrested for aggravated stalking based on use of a cell phone, which was also the second charge, use of a communication device to facilitate a felony. So looking for the said cell phone in the backpack, which is where the officer just said he found it, I think is more than reasonable.
my argument, Judge, is under the recent change to the search incident to the arrest law. If we go back to the original rationale, you either get a warrant for it, or it's got to be where the defendant can obtain a weapon or easily destroyable evidence, and if it's in the back of the police car, it's just not.
I understand, but if it can still be evidence of the crime for which he's being arrested could be found during that search, I think it's reasonable. I think you're referring to the Arizona versus Gant Supreme Court case, which was a driving while license suspended, where the court specifically said they weren't going to find any other further evidence of the crime, that being driving while license suspended, inside of the person's backpack or other.
Yes, sir. Schimmel is based on the defendant's ability to obtain a weapon or easily destroyable evidence. They have the backpack in their possession at the point, based on this officer's testimony. It is locked in his police car. He doesn't have access, the defendant doesn't have access to it, doesn't have the ability to obtain easily destroyable evidence from it. So I'm objecting to introduction at this time with this predicate of that evidence. I mean, if we need to, we can have a motion to suppress hearing on it later, but just in terms of today's proceeding, I'm objecting.
Any response, Ms. Herndon?
Your Honor, I think a phone is easily destructible device. It is something that has to be switched into airplane mode in order for a warrant to be done. I don't believe that argument has any merit.
Okay, I'm going to overrule the objection, Mr. Williams.
Officer Norton, when you searched the backpack, what did you find?
Upon opening up the backpack, we found a firearm inside of the backpack that was consistent with the victim's statement. She had mentioned 2 separate firearms that he's known to carry on his person. The first she had mentioned was a AR-style rifle that he keeps in his waistband. The second, she had mentioned it was a .380-style handgun with an extended magazine. Right when I opened the backpack, I saw what I believe it was a Taurus 9mm with an extended magazine.
And did you find anything else that was contraband?
Yes, ma'am. We found a large container, plastic container with a white powdery substance, as well as approximately 10 more bags consistent with the one that were found on his person. Field tested the substance, and it field tested presumptive positive for fentanyl. There was also a yellow Dollar General bag that was in his backpack. It was torn up. He did have there was one small section of the bag that he had torn off, and it had a prepackaged amount, approximately less than 1 gram of the same substance from the bottle, which again, field tested presumptive positive for fentanyl.
Officer Norton, during the investigation or during this transaction, did you get a presumptive weight for the substance that was found in the backpack?
Yes, ma'am. The initial total package weight was, I believe, 54 grams. I did go back and reweigh the actual, just the powder or the white substance, and I believe the final weight was 38 grams. I would have to double check with you on that one.
Sir.
But we also did find the cell phone as well in his backpack.
Thank you. Those are my questions.
All right, Mr. Williams. Ross?
Of course, we don't have FTLE reports back on any of that, do we?
Not at this time, sir.
Okay. And did you zero the scale prior to testing the white powder? And what did you place the white powder on, and how did you zero the scale?
So, yes, sir, I turned it on. I made sure that it was zeroed out. It showed no weight on the scale, and then I weighed the substance.
Did you put the substance on lab paper?
So initially, sir, no, I didn't place any paper or anything on it because it was in the closed container and I didn't want to open it based on the fact that it was a very fine powder. I didn't want to take the opportunity or the chance.
Right. So you weighed it in the container?
Yes, sir, which is why I said the total package weight.
All right. Nothing further, Your Honor.
No redirect, Your Honor.
All right, you can proceed, officer, or you're free to go.
I was nervous.
You're okay. Mr. Williams. I'm sorry, Ms. Herndon, no other witnesses. I made that assumption. You said one witness earlier, Mr. Williams.
No witnesses, Judge.
Okay. Argument, Ms. Herndon.
In this case, Your Honor, the defendant has been charged with 2 crimes that are classified as dangerous felonies under the statute, the aggravated stalking as well as the trafficking in fentanyl. The testimony was uncontroverted and pretty clear regarding some messages that were coming through over a several-day period of time that were threatening in nature that continued when Ms. Grice had asked the defendant to stop. When the officers made contact with Mr. Bell and detained him and placed him under arrest, the testimony was clear that there was a baggie with residue in his front pocket. Then there was a trafficking amount of fentanyl, even in the no package weight where Officer Norton testified that he had weighed after at 38 grams is still in excess of 28 grams. There was also a firearm located with that. Your Honor, based on the fact that Ms. Grice is in fear of Mr. Bell, that the messaging continued after he was asked repeatedly to stop that contact, we do not believe that there is any kind of restrictions that short of detention that would ensure the safety of Ms. Grice, along with the fact that obviously Mr. Bell was found in possession of a very large amount of fentanyl along with a firearm and packaging that was consistent with distribution. Based upon that and the danger of the community, the evidence, obviously the state has proven a substantial likelihood that the crime has been committed. We are asking that pretrial detention be placed on Mr. Bell.
All right, Mr. Williams, your argument.
Thank you, Judge. Judge, most of the evidence you heard today was conclusory from the officer. No text messages were admitted into evidence. No messages were even read directly from the phone. In terms of the, we had a discussion in the earlier case. The status of the law is right now is that the regular rules don't apply of evidence, but nevertheless, I think the court can take that into account in determining whether or not the burden has been met, that although essentially the hearsay evidence is admissible, it's generally given lesser weight. In terms of, more specifically in terms of weight, we're just going to have to wait and see what FDLE comes back with, even though if this is fentanyl. We are starting to see some cases where substances are reacting to the presumptive test that law enforcement does and are then coming back from FDLE, no drugs identified. Certainly, the court's aware that the mixture rule does not apply when we're talking about packaging. And FDLE will do a proper lab weight. They'll zero the scale with lab paper on it and then test just the substance.
Did I miss a portion? He said he measured it with the packaging and then without the packaging, right?
He did, Judge, but when I started asking him about zeroing the scale and whether or not he used any lab paper, we kind of got on a totally different track. He didn't seem to know what I was talking about. So I'm going to suggest we need to see what FDLE comes back with. Plus, again, we don't know that his presumptive test is actually going to be accurate in this case. These have not been accurate in all cases.
Continue with your argument.
So, Judge, based on that, I'm going to ask that the court give him a bond, and then we can discuss the parameters of that bond. Certainly in terms of protection of the victim, a GPS, active GPS with an exclusion zone is normally used in domestic violence, stalking cases of that nature. Thank you, Your Honor.
Anything else, Ms. Herndon, from the state? Okay. All right, now, obviously, I said some of these things during the last case, but every case has its own record, so I have to repeat a few things. Under 907-041 Florida statute, paragraph 1C, 5C, states that upon a motion by the state attorney, court may order pretrial detention if it finds a substantial probability based on a defendant's past and present pattern of behaviors, criteria 903-046, and any other relevant factors that any of the following circumstances exist. Obviously, we've got two different cases involving two different counts in those cases that could lead to the pretrial detention. C3 states that the defendant is charged with trafficking and controlled substance as defined by 893.135. There's substantial probability that the defendant has committed the offense and that no conditions of release will reasonably ensure the defendant's appearance at subsequent criminal proceedings. Specifically going through the facts of this case, there was found what from my memory of what the officer testified, approximately 38 grams of suspected fentanyl, that it was positive on it's often referred to as a presumptive test. Yeah, of course, there's no lab reports back. Florida Department of Law Enforcement doesn't exactly get those back within 5 days, which is the requirement as to how fast this hearing has to come. So we are going forward just on the evidence that's here. So I will find that there is substantial probability that he committed the offense. It was on his person at the time in the backpack that he was being arrested for the other case. And then going through the what I didn't hear is a whole bunch of information regarding his past and present patterns of behavior. I don't know if Mr. Bell has a prior history, and as far as the criteria of Florida Statute 903046, as far as his connections to the community, length of time in this community, family ties, immigration status, employment history, financial resources, or mental condition, which are things I'm supposed to take into account under that particular statute. I didn't hear evidence on those. And as far as there being no condition of release which will reasonably assure that the defendant's appearance at subsequent criminal proceedings, I didn't hear any evidence of any concerns about flight or any failures to appear in his record. As far as the other charge, which is the aggravated stalking, again, that's going to be 907041C5, that the defendant poses a threat of harm to the community. Court may so conclude if it finds that the defendant is presently charged with a dangerous crime, if there is substantial probability that the defendant committed such crime, that the factual circumstances of the crime indicate a disregard for the safety of the community, and there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. I kind of said that's what applies to the aggravated stalking, but I think certainly it could be applied to trafficking in fentanyl. Certainly that poses a harm to the community. Those both aggravated stalking and trafficking in fentanyl are both dangerous crimes. I find there's a substantial probability that the defendant committed such crimes. Again, the officer didn't talk about every single text message, but did give enough testimony to explain what they were, despite being told repeatedly to stop texting. The evidence was that there were 80 text messages over a short period of time, that many of them were lengthy, sometimes paragraph or more long, and the content of them was sufficient to be considered a credible threat, that the factual circumstances of the crime indicate a disregard for the safety of the community. Obviously, that there are safety concerns for the victim in the aggravated stalking, and I believe trafficking in fentanyl certainly disregards the safety of the community due to the fact that it's well known how lethal fentanyl has become, and not just this community, but across the country. Also, as far as conditions of reasonable of release that are reasonably sufficient to protect the community of the risk of physical harms to persons, we've got a situation where there's a charge and a substantial probability of committing the dangerous crime of trafficking fentanyl, which is a danger to persons, as well as the threats and aggravated stalking that went into that charge as well. So based on my findings of fact and applying those to the law, the court will hold Mr. Bell under pretrial detention in both cases until further order. I'll have that order to you later today. Obviously, we have a large docket to get through still.
Yes, sir.
Okay. Yeah, we've got to do Crooks next. The Crooks is not a hearing now. Mr. Crooks, you're here in 25 CF 696, where you were arrested for possession of a weapon or ammunition by a convicted felon, possession of narcotic equipment, and resisting an officer without violence. And in 25 CF 697, damaging property, criminal mischief, 2 counts of simple assault, and burglary with assault or battery. I believe I had you at first appearance over the weekend.
Yes, sir.
And you said that you didn't need a public defender appointed.
Judge,
You
our
reconsidered that
file-
at this point.
Yeah, no.
Okay, are you wanting a public defender appointed to your case? That would be Mr. Williams, as, I don't know if he'll ultimately be the attorney who handles your case, but are you wanting a public defender appointed? Okay, are you currently employed?
No, not at the moment, no.
Okay, and how long has it been since you've been employed? Okay. Based on that, you're going to have to fill out an application, but I'll provisionally appoint the public defender's office to represent you for the purposes of this pretrial detention hearing. It's my understanding, Ms. Herndon, the state's not pursuing pretrial detention in this case?
That's correct, Your Honor.
Have y'all talked about it? I guess Mr. Williams just got on the case about 4 seconds ago, so y'all probably haven't discussed that yet.
Judge, actually, we thought I was on the case. I went out and saw him this morning.
Okay.
I did get some information from him regarding bond and advised him that as of my last look, the state had not filed a pretrial detention motion.
Okay, so since the state's not going forward on pretrial detention, we'll just turn this into his bond hearing. State's position on bond?
He is charged with a punishable by life felony on the burglary with battery. However, I will let the court know that our office has had contact with the alleged victim, who I believe is the defendant's sister in this matter. And our understanding is that she had, if he was granted release, had wanted the no contact modified to no contact. He does have a prior record consisting of grand theft, battery, child abuse, violations of injunction. It would appear that there is likely a substance abuse issue as well. What we would request on the burglary with assault or battery would be a $25,000 cash or professional bond. On the simple assault, it appears there's 2 counts, doing a $500 cash or professional on each of those, $500 on the criminal mischief. There is possession of a weapon or ammo by a convicted felon. We would ask for a $10,000 cash or professional bond. And the remaining 2 misdemeanors, resisting without violence and possession of paraphernalia, would be fine on $500 cash or professional on each. We would ask if Mr. Crooks is released, that he be placed on pretrial supervision and that he be tested randomly to make sure that he is not using any illicit substances without a prescription, that there be a no violent contact order placed between he and the victim in this case, and to
Okay, Mr. Williams?
Judge, I think we're fine on the no violent contact order. He said okay when the state announced that not going to her residence. He's not going to be able.
Wasn't residing there at the time, right? That's why I'm guessing there's the burglary charge. I just want to make sure it's clear. Okay.
He'll be instead going to live with his mother over in Laurel Hill, 3131 Rice Road. Judge, but he's not going to be able to make a bond that high. We're asking for a $4,000 to $5,000 bond. He does do volunteer work for Helping Hands, but he doesn't have a regular paying job.
Anything else, Mr. Williams?
Judge, just that he's lived in this area for 30 of his 33 years of age. And again, our understanding is that the alleged victim is asking for no violent contact on it.
right, what I'm going to do is the following. As far as bonds in the 25 CF 697 on the burglary with assault or battery, it's going to be a $20,000 cash or professional bond. That is an offense that's punishable by life in prison. Obviously, the state is advised that the alleged victim in the case is a family member who still wants to have contact, although no violent contact. I certainly take that into account when determining what the bond is on such a serious offense, which again can be punished by life in prison. On the 3 misdemeanors, it's going to be $500 cash or professional each, so that'll be a total of $21,500 on that particular case. As far as 25 CF 696 on the possession by a convicted felon, I'm going to do $2,500 cash or professional bond on that, as well as $500 per count on the other misdemeanors. I think by my math, that gets us to about $25,000 total cash or professional bond for you, Mr. Crooks. If you are to be released, no violent contact with the alleged victims, which means you can have contact as they've asked for, but you can't do so in a violent nature. I know that's kind of a less than explicit way of explaining that, but obviously if there's an argument that ensues in any way, I would suggest that you go the other way. No return to the victim's residence. Even though you're allowed to have contact, you can't go back to the house. You're also to be on pretrial services. Do not possess any alcohol or controlled substances without a valid prescription for those substances, and you'll receive random urinalysis for the detection of controlled substances or drugs. If you're to test positive, that could be a violation of your pretrial release, and you could be rearrested. Do you understand all that, Mr. Crooks? All right, any other questions on that, Mr. Williams?
No, Your Honor.
All right, Ms. Herndon, anything else from the state?
No, Your Honor.
All right, so obviously there's not going to be a pretrial detention based on the state not pursuing that with a motion, but that is the bond amounts that I've set as well as the conditions. I'll get that order to you later today.
Thank you, Judge. Thank you. All right, sir.
Thank you, Mr. Crooks. All right. I think we've now finished our pretrial detention docket. That started at 12:30. We're now to start our 1:30 docket, which is arraignments. All right, for those of you who are here for the 1:30 arraignment or plea date docket, make sure you're listening to what I'm about to advise you. What I'm going to do is go through the docket. I'm going to call each case. When you're called, come up to this podium to my right, your left, and then I'll advise what the charges are against you, confirm whether or not an information, which is a charging document, has been filed against you. If you're not represented at that time, I'll ask you if you want me to discuss with you appointing a public defender, and based on what happens after that, I'll ask what your plea is, and then potentially set you for a new court date. If you have any questions, you can certainly ask, but this is a relatively limited proceeding regarding just your plea to the charge. All right, let's start at the top with. Okay. Okay, let me do the first one, and then we'll bring him up. All right, Barbara Abrams. Is Ms. Abrams here? Okay.
Good afternoon, Your Honor.
All right. Mr. Maddox.
Your Honor, Ms. Abrams is here before the court on 25 CF 505. Your Honor, at this time, went to plead not guilty, request trial by jury, and 15 days for any pre-arraignment motions.
All right. Ms. Abrams, did you hear all that? All right, they've entered a plea of not guilty for you. The public defenders already represents you. Mr. Sheik.
Yes, Your Honor, I just wanted to state for the record that the offer that they had to do mental health court is, we are still allowing that if she wishes to go forward with that.
Okay. All right, so what is our date on her going to be? Okay, put her at 1. Okay. All right, so Ms. Abrams, your next court date's going to be our pretrial conference date. That's going to be June 23rd at 1 o'clock. Make sure you're here at 1 o'clock, because previously they may have put it for 9, and I don't want you to come and sit here for 4 hours waiting for your case. So make sure you come at 1 o'clock on June 23rd. Messenger. All right, good morning, Mr. Messenger. You're here in 25 CF 400, listed as an out-of-state fugitive from justice. Mr. Sheik, does the state have anything about this particular case?
No, I'm not sure where they are in the process, Your Honor.
All right, Mr. Messenger, it was my understanding that you didn't sign a waiver of extradition. Do you recall that or not?
I haven't signed anything.
Okay, do you want to have an extradition hearing where we have a hearing to determine whether or not we're going to have, I think it's Oklahoma come pick you up? Or do you want to waive that?
Well, I'd rather pay my bond. It's $200.
You have a bond from Oklahoma?
I have a bond from the jail here.
Well, we wouldn't have set a bond on your.
The extradition court did.
Who was that?
The extradition court.
When did that happen?
About a month ago. It's $2,000, and with a bondsman, it'd be about $200.
I don't recall seeing that. Definitely wasn't me. I just want to know what was done.
I got family down here.
Hold on just a second. I don't see that you ever had a hearing on this, sir. Oh, wait, hold on. What happened last time? Oh, we just set you for today.
My grandma Messenger's in Beverly Hills,
Okay.
and my dad's brother, Randy,
Let me
is
ask
down
you this.
here.
I don't see where a bond has ever been set for you like that.
Right.
I think you had you had another case that was local, a misdemeanor case.
They picked me up for drinking a beer in Walmart. Can you believe that?
Well, if you don't pay for it first, yeah, I do believe that.
Yeah, I mean, I guess I didn't pay
Hold on,
for it.
Mr. Messenger, hold on. I see that you had that case, which was 25 MM 268, where you've already entered a plea to that case. Do you understand that? So that case has been resolved.
They picked me up on basically stealing a beer and
Okay,
some
but
clothes.
you've already pled to that, so your case here is done. Would you like to have an extradition hearing, or do you want to waive that and have Oklahoma come pick you up?
Just pay my bond from
You don't have a bond, sir. That's what
the
I'm trying.
extradition place did.
Okay, no, they don't. It's, you're confusing your local
That's what they
case.
said to me.
Okay, well, I'm telling you that if someone advised you of that, they advised you incorrectly. Would you like to have an extradition hearing, or would you like?
No, I don't want to have extradition.
Would you like to waive your extradition hearing?
Yeah.
Okay.
Yeah, waive that.
So what we can do is get a form for you, and bring you back on a new date, but we can get one sent over. Do you want me to appoint a public defender to help you out with this?
Public defender?
Sure.
No, I'm a good Philadelphia attorney, so I got it.
You're a good Philadelphia attorney?
Yeah, you ever heard of that? It's always sunny in Philadelphia.
Okay. All right, so what I'm going to do is I'm going to appoint the public defender to help you out, and then they're going to have you take a look at the waiver of extradition form. I think you would have seen it at first appearance. If you want to sign that, we can do that, but that's not what we're here for
Yeah.
today.
Yeah, because like I said,
What's our next miscellaneous?
my grandma down here, my uncle's down here, Lori, Cindy, Randy, Linda.
Okay, well, that's not the
So-
issue, sir. It's not
Oh,
about-
yeah, and I got a resident here at my RV mill. So I'm not homeless, I got a resident here.
Well, this is what I'm going to do. I'm going to put you on my, we may have to talk about that date. It's probably, okay, I'm going to put you on May 8th at 1:30. However, if an extradition waiver is signed, Mr. Messenger, I'm up here. Hi, I'm the
I was
only
just
one.
saying hi.
I'm the only one talking to you, though.
Nice to meet you.
All right. Yeah, so I'm going to bring you back on that date. However, if you sign the waiver of extradition, like you've talked about, and after advice with the public defender's office, then we won't have to have a hearing because I'll come and get you.
Sounds good to me.
Okay, so they'll do that, and otherwise we'll see you back on May 8th.
So
Have
the
a
only
good day,
thing I
Mr.
wanted to
Messenger.
say is that I'd rather go back to my address here.
I understand that, except we're holding you for Oklahoma because they have a warrant for you.
A warrant for what?
Somebody will come talk to him, Judge, at the jail. Somebody will come talk to you at the jail and explain it.
Felony failure to appear based on a battery on a medical care provider, threatening to perform act of violence, driving under the influence, possession of
We have the governor's signature here in Florida on that.
That's why I'm asking if you want an extradition hearing or not.
An extradition hearing for what?
All right, I'm going to have them come talk to you. We're going to set you for May 8th at 1:30. Thank you, Mr. Messenger.
The governor, hold on.
Thank you, Mr. Messenger.
The governor's got to sign off on it.
That's why I'm asking you if you want an extradition hearing. That's what that involves.
My name's Ron Messenger, nice to meet you.
We'll explain it, Judge.
Okay, thank you, Mr. Russell. All right, back to regularly scheduled programming. Stephen Arnett.
Also, that might help you guys as well. Just a couple words from me.
Okay, perfect. Your Honor, one to a plea of not guilty this time, request 15 days for any pre-arraignment motions and trial by jury.
Okay, Mr. Arnett, have there been any cases with no information from? All right, so Mr. Arnett, you were charged with battery by strangulation in 25 CF 492. Plea of not guilty is entered. You're going to go on, it's going to be June 25th at 9 a.m. for your pretrial conference. All right, thank you, Mr. Arnett. We'll see you back on that date. I just asked you. All right, Brittany Barker. Who's the state on Barker?
Your Honor, it's Ms. Berrickman's case. I'll be covering that for her today.
Okay. What's happening with Ms. Barker at this point?
Judge, we had an evaluation at Bridgeway. We provided the paperwork to the state. I think they were waiting to decide about a filing decision based on that paperwork.
Your Honor, according to our notes, we were waiting for the results of that evaluation. That was supposed to be provided by Ms. Barker or her attorney, and that may resolve the case. So if you
Has
could
it
get
been
with Ms.
sent
Berrickman
over?
on that.
We received it. Y'all didn't get it?
Not according to our notes.
I see the reciprocal discovery April 2nd, so 8 days ago.
Pass it for a second, Judge, and I'll let her look at my copy.
Okay. We'll pass it. We'll call you back up, Ms. Barker. I just want to keep bringing you back. I think this is your third time.
Ms. Berrickman's been in trial, so she may have.
I'm not upset about it. I don't want to keep setting more dates for her to show up just to be told we'll come back later. So if y'all can figure it out, that would be great. All right, David Beck. I'm going alphabetically other than the one exception that we had.
Yes, sir.
So just pay attention to your names. All right, Mr. Beck, you're here in 25 CF 493. It's a charge of felony petty theft. Do you understand that?
Oh, yes, sir.
Can you afford an attorney to represent you in this?
I'm gonna try to seek a private attorney, sir. Can I tell you what happened?
No, it's not a trial, sir.
Okay, this is, yes,
Is
sir.
there an offer from the state for Mr. Beck yet?
Yes, Your Honor. The offer from the state is an adjudication of guilt, 2 years of probation, $28.90 in restitution to Walmart, and no trespassing at the Walmart.
Okay, so
Sir.
you don't want to do that?
No, sir.
Which is fine. So I'll put in a plea of not guilty for you. I'm going to put you on a pretrial conference date of June 23rd at 9 o'clock. If you hire an attorney, you'll just roll right into that. Shouldn't be a problem.
Okay,
If you
sir.
need a public defender, you can go to the clerk's office on the first floor, fill out an application, and they can be appointed that way.
June 23rd?
June 23rd. They're going to, do we have papers on the, they'll hand you one. But June 23rd at 9 o'clock will be
Yes,
your
sir.
pretrial conference back in front of me in this courtroom.
Thank you, sir.
Thank you, Mr. Beck.
Thank you.
All right, Caitlin Bramble. Inmate.
I know it says Mr. Williams on the docket, Your Honor, but that will be my case.
This is 2025 CF 159. Ms. Bramble's charged with grand theft motor vehicle.
Yes, Your Honor. We'll enter a plea of not guilty this time. Request 15 days for any pre-arraignment motions and a trial by jury. Just for the court's knowledge, Your Honor, I will be pursuing a competency evaluation in this matter.
All right, not guilty plea has been entered. It'll be, she really set on 4/28? I think that's a little bit early for a pretrial conference, Mr. Max, to put, it's only a couple of weeks, especially
Yes,
if
Your
you're
Honor,
going
we
to be seeking an evaluation. So let's go ahead and put her on the June 25th date at 9 o'clock, and hopefully everything can get done in that time.
Yes, Your Honor,
All right,
thank you.
we'll see you back on that date, Ms. Bramble.
Am I allowed to add anything?
About? You have an attorney here who's present if you want to speak with him real quick.
Your Honor, I'll address those concerns myself. I'll go talk to her about that.
Thank you, Ms. Bramble. We'll see you back at your pretrial date.
Am I allowed to self-represent?
If you'd like to do that, we'll have to set you for a Nelson hearing. So just file something with the court and we can address it.
When can I do that?
Whenever you file something, we can set it for a hearing. Okay, we'll discuss that with Mr. Maddox.
I'll go and see her
If not,
again,
you
Your
can
Honor.
certainly file something. Thank you, Ms. Bramble.
I'll be up to see you. Okay, I'll come talk to you.
Ryan Carr.
Thanks, Caitlin.
Mr. Maddox, I think this is you.
Yes, Your Honor. Mr. Ryan Carr.
25 CF 405, Ryan Carr.
Your Honor, at this time, we'll enter a plea of not guilty. Request 15 days for any pre-arraignment motions and trial by jury.
It's a charge of felony criminal mischief. We'll set this on the June 25th at 9 o'clock docket. All right, thank you, Mr. Carr. Barry Castleberry.
Your Honor, if we could pass, well, I'll let him come out first. Your Honor, Mr. Castleberry has been offered a plea to a lesser included offense. I've discussed it with him. He intends to accept the state's offer on that regard. So we could just pass this case. I'll write it up.
Can we keep him here? All right, they'll bring you back up once they've had a chance to go over the paperwork with you, Mr. Castleberry, but it'll be today. So we'll send you back. You'll come up later. All right. Casey Cordell.
Your Honor, this is Miss Casey Cordell, present and approaching. She's here before the court on 25 CF 512, Your Honor. At this time, we'll enter a plea of not guilty. Request 15 days for any pre-arraignment motions and trial by jury.
All right, Ms. Cordell, a plea of not guilty has been entered. You're going to come back for pretrial conference on June 23rd at 1 p.m.
Yes, sir.
That might be, you might have some paperwork that says 9 a.m. It's going to be 1 p.m.
Yes, sir.
We'll see you back on that date. Stay in touch with your lawyer. James Edge. James Edge here. State asking for?
Thank you. Yes, a KPS, Your Honor.
All right, KPS, no bond on Mr. Edge. I'm looking at his bond paperwork that says today at 1:30, and he's not here. Obviously, if he shows up, we'll readdress it. I don't think he had a lawyer. No lawyer. All right, next case is going to be DeAndre Frederick. Your name, sir?
Yandre Fredericks.
All right, Mr. Frederick, you're here in 25 CF 438, charged with felony battery. Do you understand that charge?
Yes, sir.
Can you afford an attorney to represent you in this case?
No, sir.
Are you currently working?
No, sir.
All right, I'm going to have you fill out the application. Are they up there, Mr. Maddox? Okay.
Yes, Your Honor, right.
All right, so take one of those applications, fill it out before you leave here today, go turn it into the clerk's office on the first floor. Otherwise, they're going to give you an appointment to go meet with the public defender over there, and you're going to come back on June 23rd at 1 o'clock for your pretrial conference.
Yes, sir.
We'll see you back that day. Talk to them before you leave. All right, and the other Frederick, is it Yandre? Johandre, okay. All right, Mr. Frederick, you're here in 25 CF 437. Looks like you've got 2 counts of felony battery. You understand those charges? All right, can you afford an attorney?
Sure.
All right, I'm going to appoint the public defender to represent you. I would guess that at some point they may move to withdraw from one of your cases because of conflict in representing you both, but I'll let them make that determination. Mainly the thing is if they've represented one of you in the past, they'll probably keep that person and withdraw off to the other, so I'll let them make that decision. But ultimately, one of y'all will probably end up with the Regional Office of Conflict Counsel. Otherwise, we'll send you to June 23rd at 1 o'clock. All right, Joseph Gainey. All right, Mr. Williams, you're here with Mr. Gainey in 25 CF 411.
Yes, Judge. We'd had Mr. Gainey in court before the state had tendered an offer. He was going to think about it. If we can pass him for a few minutes, I tried to call him and was unable to reach him. This will give me a chance to talk with him about it.
He's been here for a while this afternoon, I know that. So why don't you pass it and I'll bring it back up.
Thank you, Judge.
Mr. Williams, you were in 3 straight hearings, I know that, but he's been here for a while today. So why don't you talk to him, we'll recall him,
Yes,
tell
sir.
me when you're ready.
All right, Judge, I sure will.
All right. Stick around, Mr. Gainey. Trayton Glass. Inmate? Glass?
Judge, Mr. Glass was transferred. I think you signed the order a day or so ago.
He's already sent to Fort Walton?
Yes, sir.
Okay. Has he got a new date?
Yes, he does.
Okay, perfect. Gloria Green? Okay. So what are we going to, were you representing her?
Yes, Your Honor. Gloria Green would be before the court in 25 CF 494. I'd obviously ask her appearance to be excused due to the medical emergency. Your Honor, we'll enter a plea of not guilty on her behalf, 15 days for any pre-arraignment motions, and a trial by jury.
June 25th at 1 o'clock for pretrial conference for Miss Green.
Thank you, Your Honor.
Hope she's feeling better. June 23rd. Thank you for correcting me. June 23rd at 1 o'clock. Sorry, I got that one wrong, and my boss corrected me. Cody Hager. Mr. Williams. Did he walk off? This is 25 CF 514.
They have an offer in the case?
Unfortunately, at this point, it would be a Department of Corrections offer. We're still looking into some more potential treatment and stuff, but it would have to be DOC at this point.
All right.
Thank you.
Mr. Williams, I think we're just going through your portion of the alphabet, but this is Mr. Hager in 25 CF 514, charged with 1 count aggravated battery on a child, 1 count child abuse without great bodily harm.
Yes, Judge, I've already spoken with Mr. Hager. I'm going to enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions, and demand trial by jury.
June 23rd at 1 o'clock for pretrial conference.
Thank you, Judge.
Can I get that written down?
All right, stay in touch with your lawyer, Mr. Hager, meet back on that day.
Yeah, wait just there, I'll write it down on a sticky pad for you.
Fulton Keaton. Inmate.
He's in lockup, Judge.
What does your alphabet go to, Mr. Williams?
It was going to be A through K, but now on newer cases coming in, it's going to include the old alphabet, so it's just, it's kind of a, I don't know.
Okay. Okay. We can take Havens then.
I live to serve, Judge. I go where they tell me to go.
All right, this is Alicia Havens. She wasn't on my docket initially, but here she is in 25 CF 44. Mr. Williams, you're listed as her attorney.
All right,
It is
Judge.
a grand theft, so a third-degree felony might be in of Mr. Maddox.
That will wind up, or might be going to Mr. Maddox. I'll go ahead and appear for today's purposes, though. It was not on my docket, so I haven't spoken with her.
I think she failed to appear, and then she was just at first appearance yesterday. They must have bumped her up to today.
All right, Judge, let me go ahead and enter a plea of not guilty on her behalf. The usual 15 days for pre-arraignment motions, demand trial by jury. I'll get the file pulled at the office and take a look at it, and if it looks like it can be resolved, I'll bring her in as quickly as we can.
Otherwise, Ms. Havens, it's going to be June 25th at 9 o'clock for your pretrial conference. We'll see you back on that day.
So I'm incarcerated until June?
Your attorney's going to come out and talk to you. Looks like there's a no bond based on the failure to appear.
June 25th?
June 25th. But if y'all work something out and want to try and get it in front of me earlier, I'll certainly take it. I just,
Yes,
he has to come out and talk to you.
Ma'am, I'll add you to my list for next week, okay?
Keaton, okay.
Next week to see me?
Yes, ma'am, to see you.
Aren't on this docket, but are on this docket.
Hang on a second. You want to take that with you, okay? That's yours. I was just writing down your name. Yes, ma'am.
All right, this is Colton Keaton, 25 CF 472, and there's 21 CF 2013.
Yes, Judge, he also has a VOP on the 2 p.m. docket, so if we can handle both of those, I'll enter a plea of not guilty for him on this case, demand trial by jury, ask for 15 days for pre-arraignment motions, and enter denial on the VOP.
All right, do you want to put them both on the June 25th?
Yes, sir.
All right, June 25th at 9 o'clock for your next pretrial conference. That'll be both the new law violation and the violation of probation cases. All right, let's see you back on that date, Mr. Keaton.
Okay, Mr. Keaton, I'll come back out and see you again once I get something.
Okay.
Okay?
Who do you? We handled Knox this morning? Oh, that was Mr. Nopes. All right, who do you have next? Okay. All right, let's go with McNeil, and then Joshua Landry will be next.
And Judge, I'm showing this is all of mine for the 1:30 docket.
All right, thank you, Mr. Williams.
Okay.
Good afternoon, Mr. Reed. How
Good
are you?
afternoon, Your Honor. Pleasure to see you.
You too.
May I approach?
Yes, what do you have there? Okay. All right, thank you, sir. Good to see you.
Chairman, Charles Reed appearing on behalf of Samantha McNeil in case number CF 413AC. We've reached the agreement with the state, which I've just handed to you.
Calls for 60 days in county jail, credit for time served, some court costs.
That's correct, Your Honor.
The state's agreement?
That is correct, Your Honor.
All right, Ms. McNeil, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Savannah Ray McNeil, August 7th, 1993.
All right, Ms. McNeil, you're here in 25 CF 413, currently charged with fleeing and eluding law enforcement with lights and siren, which is a third-degree felony punished up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that calls for you to do 60 days in county jail with credit for any time served, $518 court costs. $548 court costs.
Sure.
I'm going to fix that for you guys.
Please, Your Honor.
I can't keep track of them either, Mr. Reed. They change on a lot of different issues. All right, $548 in court costs. What I can do, Ms. McNeil, is give you 60 days once you get out of jail to set up a payment plan. Otherwise, they'll be sent to collection on those court costs. Is that okay?
Yes, sir.
All right, Ms. McNeil. Did you go over this paperwork with your attorney, Mr. Reed?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
If you had any questions, did Mr. Reed answer those for you?
Yes, sir.
Are you satisfied with his advice and representation?
Of course.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone promised you anything in return for this plea?
No, sir.
Has anyone forced, pressured, or threatened you to enter this plea?
No, sir.
Do you understand that if you enter this plea, there won't be a trial of any kind, you'll be giving up your trial rights, which are listed on page 2 of the agreement you signed?
Yes, sir.
You understand you're waiving any potential defenses that you may have?
Yes, sir.
You understand that if you're not a U.S. citizen, this case could lead to your deportation?
Yes, sir.
All right. And what is your plea?
No contest.
All right. I'm going to accept your no contest plea to the fleeing and eluding as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty, 60 days county jail. Credit for time served, $548 in court costs. You have 60 days from your release from jail to set up a payment plan with the clerk to pay those off. Otherwise, they'll go to judgment. Do you understand that?
Yes, sir.
Any questions? All right, I'll need you to be fingerprinted.
Your Honor.
You have 30 days to appeal the judgment and sentence.
Your Honor, if I may,
Yes, sir. Oh, one quick question before you do. I didn't get us guidelines on Ms. McNeil.
You didn't get, was it?
I've been furnished one, Your Honor.
You didn't furnish one?
I've been furnished.
You have it.
The state
Is this
furnished
is this a guideline sentence?
It does not score.
Okay, if you could still provide those so I can sign off on that.
Yeah,
When you get it to.
Your Honor, I would ask the court to convert the court cost to a civil lien. She's on hold from Santa Rosa County, so,
Okay, so she doesn't need the payment plan, is what you're saying, just make it go straight to judgment.
yes, sir.
Okay, then we'll
And
change that.
we'd ask the court to allow her to, she's only got a few days left here, less than 10, to be transported to Santa Rosa County and serve the remainder of the 60 days in Santa Rosa
I'm
County.
fine with that once they pick her up.
Yes, sir.
All right, thank
And
you.
and that may be today or a week from now.
So
couldn't tell you.
just clarification, so will like paperwork be signed for me, or do I have to wait until my sentence is over here? Or can I go ahead and go over there and serve them?
I'll
for me?
sign the paperwork once it gets to me. I don't know how quickly that will be. What is today, Thursday? Sorry, I've been on duty. This is my 11th straight day.
Okay,
I'm losing track of what day it is. Today's Thursday. I would guess it might be next week.
okay, yeah, that's fine. I just want to
But
make
I'll
sure.
sign the paperwork as soon as it comes in.
Okay,
All right.
Who
Thank
sends you that
Sounds like you're
paperwork?
earning your money, Judge.
I'll get it, ma'am. When it
Okay.
comes in, I'll sign it.
All right.
It's not Mr. Reed or the state attorney, so.
okay, thank you.
All right.
Judge, just to let you know, I talked with Mr. Gainey. We can go ahead and handle that whenever you're ready.
Okay, let me get through a few other people first, and then we'll get back to him. All right. I think I called Mr. Landry.
Not guilty.
Okay. So that'll be June 23rd at 9. All right, Tyler Mims Curry. Thanks, Dan. All right, your name, sir?
Tyler Mims Kerr.
All right, Mr. Mims Curry, you're here in 25 CF 445, charged with distribution of marijuana and possession of narcotic equipment. Do you understand those charges?
Yes, sir.
Can you afford an attorney to represent you in this case?
No, sir.
Take one of those applications that's in front of you. I'll go ahead and provisionally appoint the public defender's office, but you're going to have to fill out that application, turn it in downstairs before you leave on the first floor to the clerk's office. And then we'll see you back on June 23rd at 1 p.m.
Judge, for the record, state's filed an informational enter a plea of not guilty, trial by jury, 15 days for any pre-arraignment motions.
All right.
At 1 o'clock.
Thank you. All right, Evan Pace.
Your Honor,
You need,
may I approach Ed McNeil's?
please do. You're fine. Don't rush. Don't rush.
Mr. Pace. Your Honor, this is Mr. Evan Pace before the court on 25 CF 256. At this time, Your Honor, went to a plea of not guilty, request 15 days for any pre-arraignment motions and trial by jury.
All right, we'll see you back, Mr. Pace, on June 25th at 9 o'clock. All right. Rocky Robinson.
Good afternoon, Your Honor. This is Rocky Robinson. Is before the court on 25 CF 404. We're going to tender a not guilty plea and request trial by jury.
All right, Mr. Robinson, we're going to set you for a pretrial conference. That's going to be, do you want June?
Yes, please.
All right, June 25th at 9 o'clock. And I'm sure Ms. Rivers will be out to see you in the meantime.
Sure.
All right, Christian Rosario.
And Your Honor, if I may, the state just made a pretty favorable offer for Mr. Pace that he may want to take if we could pass him to the 2 o'clock.
For who?
Mr. Evan Pace, Your Honor.
Pace?
Yes, sir.
You want to bring him back?
Yes, Your Honor.
Okay. All right, we'll bring him back for the quote-unquote 2 o'clock docket.
Thank you, Your Honor. Your Honor, this is Mr. Christian Rosario, 25 CF 443. Your Honor, at this time, we'll enter a plea of not guilty. Request 15 days for any pre-arraignment motions and trial by jury.
All right, Mr. Rosario, you're going to come back on June 25th at 9 o'clock for your pretrial conference. All right. Thank you, sir.
I'll come see you again, Mr.
All right, Christian, is it Russa? R-U-S-S-A-W? Alpros, okay, that's easy. All right, Robert Schofield.
Your Honor, at this time, Mr. Schofield's before the court in 25 CF 495. Your Honor, went to a plea of not guilty, request trial by jury and 15 days for any pre-arraignment motions.
Looks like he's got another case on the April 30th docket. Do we want to put them together somewhere?
That's fine. Yeah, we can do that.
Which date would you like?
The 4:30 date is fine, Your Honor. I don't think there'll be much of a development, at least with this case, but it's fine to track them together.
Would you rather me just put them on June if nothing's going to happen with this case?
Well, no, there are
Up
other.
to you. I just
No,
wanna-
not at this time, Your Honor.
Okay. So let's put them both on the April 30th at 9 o'clock docket.
Okay.
And we'll see you back on that day, Mr. Schofield.
Come see.
All right. All right, thank you. Thomas Selman. All right, Mr. Selman, you're here in 25 CF 401. Charges have been filed against you for battery on a law enforcement officer, assault on a law enforcement officer, and resisting without violence. Do you understand those charges? I need to hear you, sir.
Yes, sir.
I know you're nodding, but I need to hear you. Can you afford an attorney to represent you in this case, Mr. Selman?
No, sir.
All right, I'm going to have you fill out an application, but take it downstairs on the first floor, fill it out, and turn it in before you leave here today.
Your Honor, I believe we've reached an agreement in this matter.
Okay. Okay. Do we have a score sheet too?
Yes, Your Honor.
If I may approach.
Remember when they used to call arraignments no plea day? Here we are. All right, Mr. Selman, raise your right hand. Right hand. The other one. There you go. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name and date of birth, please?
Thomas Selman, number 1961.
Okay. And Mr. Selman, you're here in 25 CF 401. I've been handed a plea and sentencing agreement that has you pleading to the battery on law enforcement, which is a third-degree felony, punishable up to 5 years in state prison, as well as the assault on law enforcement officer.
Your Honor, if I may approach.
Sure. State, you want to join us? All right, so Mr. Selman, again, it's battery on law enforcement officer, third-degree felony, punishable up to 5 years in state prison, and there's also assault on law enforcement officer, which is a first-degree misdemeanor, which is punishable up to a year in the county jail. It's got you, well, then I can't give him 2 years probation on that
And
one.
Your Honor, it would have to be count 1 would be the 2 years probation, and then count 2 and 3 would be the accredited time served.
Okay. All right. So, Mr. Selman, what it would be is you're pleading as charged for the battery, the assault, and the resisting. It'd be 2 years probation on the battery charge. The other ones would be time served. As part of your battery charge, it'd be 2 years of probation, complete an anger management course, waive cost of supervision, and then a total of $967 in court costs, $100 cost of prosecution, $100 PD fee. Is that what you want to do today?
Yes, sir.
Okay. Did you go over this plea and sentencing agreement with your attorney, Ms. Rivers?
Yes, sir.
And did she explain it to you?
Yes, sir.
Did you understand it?
Yes, sir.
Did you have any questions about it?
No, sir, I don't know.
All right. I have to look down to read it, so if I can't hear you, I'm going to have to keep looking up. So, did you understand it?
Yes, sir.
All right. Did you sign it?
Yes, sir.
Okay. And are you satisfied with the assistance of your
Yes, sir.
attorney? Are you currently under the influence of any alcohol, drugs, or
sir.
controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
All right. Did anyone force, pressure, or threaten you to get you to sign this?
No, sir.
Anyone promise you anything in return
No,
for
sir.
this? Do you understand that if you enter a plea to these 3 charges, there won't be a trial of any kind?
Yes, sir.
All right. And you understand that you're giving up your trial rights, which are listed on page 2 of the document that you signed? And do you understand that by entering this plea, you'd be adjudicated guilty and you'd be a convicted felon? Do you understand that?
Yes, sir.
Do you understand that if you're not a U.S. citizen, this could lead you to your deportation?
Yes, sir.
All right. And this is a guideline sentence. This is the state's agreement.
Yes, it is, Your Honor.
Okay, Mr. Selman, what's your plea on the battery on law enforcement, assault on law enforcement, and resisting without violence?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. On each count, it's adjudication of guilt. On count 1, 2 years probation, anger management, waive cost of supervision, $967 court costs, $100 cost of prosecution, $100 PD fee. On counts 2 and 3, it'll be time served with the adjudication. Mr. Selman, you'll have to talk to probation, who's behind you there. I'm going to need you to get fingerprinted. You have 30 days to appeal the judgment and sentence of this court. Thank you, Mr. Selman. Mr. Simmons, Tyler Simmons. Yes, thank you. All right. Get information. Oh, no, I'm looking at the wrong case. How about that? All right, Mr. Sheik, have y'all filed on Mr. Simmons?
No, we have not, Your Honor. The state is not going to be filing on this case, and the offer for the misdemeanor one, I can relay it at this time. Obviously, he'll have to
Different case
accept it.
number?
It's a different case number altogether, Your Honor.
Okay.
So it's not, it's 2 separate charges. The state will, when he goes to misdemeanor court, we will dismiss this one for a plea to the misdemeanor case.
Okay. Let me try and find out. When does he have court for that? 21st. Okay. All right. So what they're saying, Mr. Simmons, is you have a court date with Judge Ward on April 21st. If you go in and plead to that one, I'm not sure what those terms were going to be. They'll ultimately dismiss the case in my court, which is the felony case. Do you understand that?
Yes, sir.
All right. So what I can do is I can put you on another court date to have you come back. In case that doesn't work out, you still have to come back before, if this one gets dismissed, you won't have to come back. But you understand what I'm saying?
Yes, sir.
Okay, good. All right. So as far as our case, I'm going to put you on the June 23rd at 9 o'clock docket. Obviously, if that case is dismissed before then, you won't have to be here. Otherwise, you will. Make sure you attend your county court docket on April 21st at 9:30.
Now it's actually at 9:30, not at 1 o'clock or 1:30?
I'm just
Okay,
reading what
okay, I'm just.
It happens, and you've heard the clerk has corrected my mistakes today too, so just, it's always good to double check right, but maybe the day before you go to make sure you've got the right date and time. All right, thank you, they'll see you on that day. All right, is it Devon Smedley? Did I miss somebody? There's that gentleman that's in there, has been in there for a little bit, so I just didn't know if I missed him.
Your Honor, Mr. Smedley's before the court on 22 CF 2688, for which we'll enter a denial, but I believe we already did the other week. And then we have 25 CF 502, we'll enter a not guilty, request trial by jury. We'll ask both cases to track together with the looks like a pretrial date of 6/23.
Yeah, I think since he's incarcerated, we'll put him on June 25th at 9 o'clock.
Thank you, Your Honor.
All right, we'll see you back on that date, Mr. Smedley. All right, it is
see what I got
Ladidra
something for you.
Smith.
Thank you.
I
appreciate it.
Mm-hmm.
Are you Ms. Smith?
Yes, sir, I am.
All right, you're here in 25 CF 407, charged with possession of a firearm or weapon by a convicted felon. You're also charged with vehicle theft, use of a weapon, or this is possession of an altered serial number on a firearm, and I believe that's all three. Do you understand?
I don't have an attorney or anything. I don't understand anything. I don't know. I ain't never been to the state of Florida, never been in trouble. I
Do you
went and
understand that's what
applied.
you're charged with?
No, I don't even understand that.
Okay, would you like me to appoint you a lawyer?
Yeah, I filled out the form and they said it wasn't processed yet, but I still had to come here.
Because the application was incomplete.
I filled out another one. I don't know how it was incomplete. If it don't apply, that's what NA is for. It didn't apply to
Well,
me.
you have to put an answer for every single question. You can't just write NA across half of the form.
It didn't apply to me.
So you have to put that for each thing it doesn't apply. You can't just, ma'am.
Okay.
Do you want it to be processed?
I refilled one out yesterday. They should process that one. Mm-hmm.
All right, looks like it was processed yesterday
Mhm.
at about 3:10. So I'll go ahead and appoint you a public defender.
Your Honor, we're going to enter a not guilty plea, request trial by jury. And it looks like the clerk has listed 4/28 for being the next court date.
Got the date that you want?
I won't be
That
available.
would be kind of soon, Your Honor, if we could do the next one.
Ms. Smith, are you okay coming back in June instead of just turning around in a couple of weeks?
Mm-hmm.
Yes?
Yes, Your Honor.
All right, let's put it on June 23rd at 1 o'clock. We'll see you back on that date. Stay in touch
Thank
with
you.
your lawyer.
Give me a call or email.
Robbie Spivey?
My attorney? Well, it's nice to know. Nice to meet you.
Ma'am, if you want to stick around, she could probably talk to you. All right. Have a good day.
We meet the nice. That's what. I think she's going to
All right, your name, sir? Mr. Spivey, you're here in 25 CF 504, charged with aggravated battery and resisting without violence. Do you understand those charges?
Oh, the aggravated battery, what was that for?
Resisting without violence was the other charge.
I don't understand the aggravated battery because there was no violence.
Okay, well, that's what it is, without violence. Resisting without violence.
I understand the charges.
Okay, can you afford an attorney to represent you?
No, I can't, sir.
All right. I'm going to go ahead and appoint the public defender.
How are you, man?
Your Honor, we're going to enter a not guilty plea and request trial by jury. It looks like it has a court date listed of 6/23.
Yes, June 25th at 9 a.m.
You okay? Yeah, I know. I recognize you.
All right, Mr. Spivey.
Is it okay I can speak with you before you leave?
We'll see.
She's got a lot of people on the docket, Mr. Spivey, so she'll see what she can do. All right, Brian, is it Sufrek?
Straufek, Your Honor.
Straufek? That's 25 CF 440.
Yes, Your Honor.
I'll put a second R in there and it just.
I think I got it right. How you doing, Mr. Straufek? Come on over. Your Honor, before the court is Mr. Brian Straufek and 25 CF 440. Your Honor, at this time, will enter a plea of not guilty, request 15 days for any pre-arraignment motions and trial by jury. Just for the court's knowledge, Your Honor, I am seeking a competency evaluation.
So let's put him on the June 25th at 9 o'clock docket for pretrial conference. Sir, we'll see you back on that date. Someone's going to come out and speak to you to do an evaluation. Make sure you cooperate with that to make it go as easily as possible. All right, we'll see you back on that date. Dustin Strawn.
Your Honor, this is Mr. Dustin Strawhan before the court. Forgive me, I don't have the file in front of me. I left it at the office. I don't remember the case number.
All right, it's 24 CF 2849, where he's been charged with possession of a controlled substance.
Thank you, Your Honor. At this time, we'll enter a plea of not guilty, request 15 days for any pre-arraignment motions and trial by jury. I'm going to double check that we don't have a conflict in this case, Your Honor.
He's currently set for the April pretrial. Is that what y'all want?
No, we can go ahead and kick that out, Your Honor.
Let's put it on June 25th at 9 o'clock.
All right, thank you, Your Honor.
Your Honor, if I may, just for the record, the original offer was an adjudication of guilt, 30 days OCJ, credit for time served, and $615 in court cost. And I think he may already have that now.
You don't want to talk about
I'll
it?
check that. I'll check on that. I'll check on that for you.
Okay. You want to recall him?
Yes, please, Your Honor.
All right, we'll recall him.
I'll look him up, make sure we don't have a conflict with him. If we don't, I'll talk to him about that.
Tiffany Streeter. Is Tiffany Streeter here? This week. All right, what's our next arraignment date? Let's renotice Ms. Streeter for May 8th. Looks like it was just transferred from Division 1 a couple of days ago, so she probably didn't get notice. All right, May 8th for her next. It looks like they may have already given her April 28th. So let's keep that docket, keep April 28th, but also put her on the May 8th docket, and then we'll handle it when she shows up from one or the other. All right, Jordan Williams. All right, Ms. Williams, you're here in 25 CF 462, charged with a written threat contributing to the dependency or delinquency of a minor. Looks like the other cases were dropped. Do you understand those charges?
Yep.
Okay. Can you afford an attorney to represent you?
I filled out the paper already.
Did you? Let's see.
Well, my pretrial did.
Let's see it in here. You have anything on her, Ms. Rivers? Okay. When do you think you filled that out, ma'am?
The same week I got out.
I don't see it anywhere, so I hate to do this to you. I'm gonna need you to fill out another one. If you could do that today on your way out, drop it off at the clerk's office on the first floor. I'm gonna appoint the public defender in the meantime.
I didn't fill it out. My pretrial did.
Well, you have to fill that out. That's probably why it's not done, because you have to fill out that part.
Your Honor, we're.
Pretrial doesn't know how much money you make and how many assets you have and all those types of
Oh,
things.
well, I filled it out sitting in the office with her. She just turned it in because I didn't have the $50 at the time, so.
Something happened where it didn't get into the
I'll
clerk's
redo it.
file. So if you could just fill that out to make sure we've got one on file, but I've appointed you the public defender.
Your Honor, we're going to enter a not guilty plea, request trial by jury. It says next date would be 6/23.
6/23 at 1 o'clock. What happened with Wolf? I have that on my written docket.
Give me a call. Okay.
Is there anyone else that was on the 1:30 docket that hasn't been called?
Judge, I can recall Mr. Gainey when the court's ready.
Yeah, if the people who think they're on the 1:30 can come up to the bench, or not to the bench, to the rail.
Come on, stand next to me, Mr.
Did I miss a page?
We're on this side.
All right, if you're on the 2 o'clock docket, I don't want you standing up and coming up to the rail. It's if you're on the 1:30, this is your first court date docket. So if you're on the 2 o'clock docket, we'll call you once we get to it. All right, this is Mr. Gainey.
Yes, sir.
All right, go ahead.
Judge, I'm just going to enter a plea of not guilty on his behalf, 15 days pre-arraignment motions and trial by jury.
All right. And Mr. Gainey, we're going to put you on June 23rd at 1 o'clock. Will be your pretrial conference. Make sure you stay in touch with your lawyer, and we'll see you back on that date.
Thank you, Judge.
Go ahead. Judge, can I recall Brittany Barker?
Brittany Barker.
She's on page 1. Case number is 25 CF 102.
Your Honor, the state has verified the paperwork that Ms. Barker has provided, and we would announce a null pros in this case.
All right. Case dismissed. Thank you, Ms. Barker.
Thank you, Ms. Barker.
All right.
Holly Godwin.
You're on the 2 o'clock docket. We haven't started that yet.
I was
So-
told to be here at 1.
I understand, but I'm not sure who told you that, but, all right, next.
Tanya Crooks.
Tanya Crooks. Also 2 o'clock. We'll get to you. I want to peek at your paperwork to see if it says 2 o'clock. We haven't got to that yet.
Roush. She has an order to show cause. Judge, that's on the Michael Jackson case.
Oh, that's okay. Brian Thompson, also on the 2 o'clock docket. We'll get to you.
Bird. Carol Bird.
That on the Jackson case too?
Yes, ma'am. She's here on an order to show cause on the Michael Jackson case.
Mr. Bird, take a seat, and I'll get back to you in a second. I'm getting a note as we're speaking. I just want to take a look at it real quick, and then we'll see what it is.
Your Honor, if I may,
Yes.
Jonathan Wolf was on the 1:30 docket today. I did file a written plea of not guilty on his behalf due to him being out of state. If the court would allow me to address his case, though the state may be willing to dismiss it today. It was just entertaining an order that the court may be able to adopt. It would take a few minutes, Your Honor.
Okay, let's address it a little later.
That's fine.
We've got a lot of people waiting still.
Of course, Your Honor. Thank you.
Just remind me.
I will.
Kelly Fernal.
You're on the 2 o'clock as well. We'll get to y'all. It's a big docket.
I'm waiting for 23.
All right, Mr. Bird, you're here for a bond remission. We'll get to that. That's going to take a minute. All right. Okay. All right, so it sounds like we don't have our 2 o'clock inmates yet, so I'm going to try to see who we can handle in the meantime. Let's see, okay. O'Shea was already continued, correct? I signed that, I don't know, earlier this week. Mr. Browning's case. Yeah, I think I continued it. It was a motion to suppress. The state needed to continue it because it was set like a week ago. And
Yes,
you guys-
Your Honor, thank you.
So, all right, Marshall, Reedon, Stillman. All right, Trellin Durham. I'm just trying to handle the people who are out of custody since we don't have our inmates for the 2 o'clock docket yet. Mr. Maddox.
Yes, Your Honor. I wasn't able to get him this before we came up. I just have a plea ready to go for him. Just need a signature, Your Honor, if we just pass him so I don't waste the court's time on that.
All right, we'll call you back up, Mr. Durham. Who else do we have that's not in custody? Talisha McTeer.
That one I have ready to go. All right, Your Honor, we've reached a resolution in this matter. I have a written plea agreement. May I approach?
Yes, sir.
Yes, ma'am. He's just
All right, Ms. McTeer, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, I've been handed a plea and sentencing agreement in 24 CF 2342, which is 2 counts of possession of a controlled substance, third-degree felony, punished by each by 5 years in prison. Do you understand that? Did you read the sentencing agreement, plea and sentencing agreement? Did you understand it? Did you sign it? Did you go over it with your attorney? Did he answer any questions if you had any? Are you satisfied with your attorney's advice? All right, calls for you to plead to both counts, adjudication of guilt, credit for time served, and court costs. Is that what you want to do? Is that the state's agreement?
Yes,
State's
it is,
agreement,
Your
that is,
Honor.
okay.
Sorry.
All right, are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you to enter this plea? Has anyone promised you anything in return for your plea?
No, sir.
Do you understand that if you enter a plea, there won't be a trial of any kind, and you're giving up your trial rights, which are listed on page 2 of the agreement you signed? Do you understand that you're waiving all potential defenses that you may have? Do you understand that if you're not a U.S. citizen, this could lead you to your deportation? This appears to be a guideline sentence. What's your plea to the 2 counts of possession of a controlled substance, Ms. McTeer? All right, I'm going to accept your no contest plea in 24 CF 2342, both counts. I'm going to adjudicate you guilty. Credit for time served. Court costs will be $518? $615 court costs. $150 to the public defender. I'm going to give you 90 days to pay or go set up a payment plan with the clerk's office. Anything that I missed?
No, Your Honor.
All
And it
right.
was a guideline sentence, like you
It was a
said.
guideline sentence. I'm looking at the guidelines and signing them now. Ms. McTeer, I'll need you to be fingerprinted, and you have 30 days to appeal.
Perfect. Thank you, Your Honor.
Thank you.
Your Honor, if I may, Mr. Williams was here representing Ms. Streeter.
Ms. Streeter.
Who was not
On the
here.
arraignment docket and not here.
Yes, Your Honor.
Okay. I think it just got transferred to us, Mr. Williams.
That's what happened, Your Honor, and I wasn't sure. I had entered a written not guilty plea. I wasn't sure if all that got transferred. I just wanted to make sure.
Tiffany Streeter.
In other words,
I looked at it when, I don't think it was there when I looked at it earlier, but it's there now. All right, so what we did is, you filed a plea of not guilty. We're going to put it on the April
28th, I believe is the next one you have.
April 28th at 9 o'clock. Yes, Mr. Williams.
Just wanted to stop by and make sure you didn't think I was ignoring you.
Oh, no, we just kept it on that docket because we saw it just got transferred and we didn't want to issue a KPS for Ms. Streeter or you, so.
Especially not Ms. Streeter. I'm used to it. Thank you, Judge.
All right. Thank you, Mr. Williams. All right, Zachary Neal. All right, Mr. Maddox, I think this is you.
Yes, Your Honor, this is me. Same thing with Mr. Neal, Your Honor. Wasn't able to catch him this afternoon. Just need a signature form. If you just pass him, I'll bring you back up.
All right, we'll call you back up, Mr. Neal. Brian Thompson. Come on up.
All right, this is Mr. Brian Thompson approaching. Your Honor, we've reached a resolution in this case. I have a written plea agreement ready to go. If I may approach.
All right, Mr. Thompson, you're here in 25 CF 339, charged with possession of a controlled substance. Can I get you to swear in? Other one?
Right here, yeah.
No, no worries. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, I've been handed a plea and sentencing agreement that calls for you to plead to that possession of controlled substance. Oh, I'm sorry, I didn't read to the bottom. You can put your hand down. Plead to a lesser included offense of possession of drug paraphernalia, credit for time served, $270 in court costs, $100 cost of defense, and 180 days to pay those costs. Is that what you want to do today? All right, can you state your name and date of birth?
Brian Thompson, August 16th, 1974.
Okay, and Mr. Thompson, did you go over this form with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it?
Yes.
Are you satisfied with your attorney's representation in this case?
Yes, I am.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Has anyone forced, pressured, or threatened you to plea?
No, sir.
Do you understand if you enter a plea, you're giving up your right to a trial and all the trial rights which are listed on page 2 of the agreement that you signed? All right. Do you understand that you're waiving any potential defenses that you may have? Do you understand that if you're not a U.S. citizen, this could lead to your deportation? Okay. And what is your plea to the lesser included of possession of drug paraphernalia?
Contest.
Okay. I'll accept your no contest plea. It's going to be adjudication of guilt, credit for time served, $270 in court costs, $100 cost of defense. I can give you 6 months to pay off those court costs, Mr. Thompson.
Sure.
All right. I don't think I need his fingerprints. Because
Don't?
it's a lesser included. It's a misdemeanor. It's not a escalating charge. All right, you have 30 days to appeal, Mr. Thompson. Really should be off. All right. Your case was dismissed. You withdrew the plea. That's the case where it turned out that the fentanyl was not. About that.
Your Honor, Mr. Durham has signed his plea agreement. If you want to just go ahead and recall
Yes, let's
him.
go ahead and call him.
May I approach?
Yes, sir. Thank you, Mr. Maddox. All right, Mr. Durham, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth?
Trelline Marquell Durham, January 30th, 1996.
All right, Mr. Durham, you're here in 24 CF 932, charged with possession of a controlled substance, third-degree felony, punished by up to 5 years in state prison. Driving without a valid license is a second-degree misdemeanor, punished by up to 60 days in county jail. And possession of drug paraphernalia, first-degree misdemeanor, punished by up to a year in county jail. Do you understand all that?
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to plead to all counts, be adjudication of guilt, credit for time served. Court costs would be $615. $150 to the public defender's office, and 90 days to pay all that. Is that what you want to do today?
Yes, sir.
Is that the state's agreement? Okay. All right, Mr. Durham, did you go over this plea and sentencing agreement? And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Did you go over it with your lawyer?
Yes, sir.
Are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you have any current issues with mental illness? All right, has anyone promised you anything in return for this plea?
No, sir.
Has anyone threatened you with anything to get you to plea?
No, sir.
Do you understand if you enter this plea, you're giving up your right to a trial and all the trial rights which are on page 2 of your agreement?
Yes, sir.
Do you understand you're waiving all potential defenses? And do you understand that if you're not a U.S. citizen, this plea could lead to your deportation?
Yes, sir.
All right, and what is your plea?
No contest. No contest.
All right, I'm going to accept your no contest plea as charged, possession of controlled substance, driving without a valid license, and possession of drug paraphernalia. Adjudicate you guilty on all counts. Credit for time served, $615 in court costs, $150 to the public defender's office. You have 90 days to pay that, Mr. Durham. I am going to need your fingerprints, and you have 30 days to appeal the judgment and sentence of the court. I do have the guidelines. It is a guideline sentence.
Yes, Your Honor.
Thank you. All right, anyone else y'all want to call? Do we have inmates yet?
Getting off the elevator now.
Does anybody have anybody out of custody they want to call back up?
Judge, what I would suggest is I've got 2 that are not in custody. One's a lengthy hearing, though. It's the rule to show cause. But the other one is Sandra Byers, Judge, back on
Byerly?
Byerly.
That's been dismissed, right?
Yes, sir.
Okay, I've already crossed it off.
Thank you.
I have both Tanya Crooks and Kelly Fernald, Your Honor, that are ready to go.
Are they out of custody?
Yes, he's talking to me.
Okay.
Yes,
Call
Your
'em
Honor.
up.
Tanya Crooks? Your Honor, we've reached a resolution in this matter. May I approach?
Yes. All right, Ms. Crooks, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your name and date of birth, please?
Tanya Crooks, 101580.
All right, and Ms. Crooks, you're here in 24 CF 1334, currently charged with possession of controlled substance, third-degree felony, punishment up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been given a plea and sentencing agreement that calls for you to plead to a lesser-included offense of possession of drug paraphernalia. It'd be adjudication of guilt, credit for time served, $270 court costs, $100 cost of defense, and 90 days to pay that. Is that what you want to do today?
Yes, sir.
Is that the state's agreement?
Yes, it is, Your Honor.
Okay. Did you go over this plea and sentencing agreement with your attorney, Mr. Maddox?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Anyone promised you anything in return for the plea?
No, sir.
Do you understand that by entering a plea, you're giving up your right to a trial and all the trial rights which are on page 2 of the agreement that you signed?
Yes, sir.
Do you understand you're waiving all potential defenses? And do you understand that this plea may, if you're not a U.S. citizen, lead to your deportation?
Yes, sir.
Okay, and what is your plea to the lesser included of possession of drug paraphernalia?
No contest.
All right, I'm going to accept your no contest plea to the lesser included charge of paraphernalia, adjudicate you guilty, credit for time served, $270 in court costs, $100 cost of defense, and 90 days to pay those costs. I don't need your fingerprints, but you have 30 days to appeal. All right, thank you, Ms. Crooks. Make sure you set that up. Oh, and it's a plea to a misdemeanor, so we don't have to worry about the score sheet.
Although I think I attached one anyways.
You did.
That's
That's why it wouldn't have been a guideline sentence, but it was a misdemeanor, so.
Yeah, we did good. Next, Your Honor, I have Ms. Kelly Fernald before the court in 24 CF 1301. Your Honor, we've reached a resolution in this matter. May I approach?
Yes, sir. Thanks, sir. All right, Ms. Fernald, you raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, can you state your name and date of birth, please?
Kelly Fernald, 11181.
All right, and Ms. Fernald, you're here in 24 CF 1301, where you're currently charged with possession of a controlled substance, a third-degree felony, punished up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handing a plea and sentencing agreement between you and the state that calls for you to plead to a lesser offense of possession of drug paraphernalia with an adjudication of guilt, credit for time served, $270 in court costs, and $100 cost of defense.
Yes, sir.
Is that what you want to do today?
Yes, sir.
State's agreement.
It is, Your Honor.
All right. Ms. Fernald, have you gone over this agreement with your lawyer?
Yes, I have.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's advice?
Yes, very much.
Are you currently under the influence of any drugs, alcohol, or controlled substances?
No, sir. No, no, sir.
There was other noise. I couldn't.
I know, I'm sorry.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
Anyone promise you anything in return for your plea? You understand that by entering a plea, you're giving up your right to a trial, all the trial rights on page 2?
Yes, sir.
And you understand you're waiving all potential defenses that you may have? Okay, what is your plea?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given to the lesser included offense of possession of drug paraphernalia. Adjudicate you guilty, credit for time served, $270 in court costs, $100 cost of defense. I'll give you 90 days to pay those costs off.
Thank you.
All right, thank you, Ms. Fernald. I don't need your fingerprints, but you do have 30 days to appeal.
Thank you very much. Thank you so much. Yes, ma'am.
Your Honor, Zachary Neal did sign his plea agreement. If you want to go ahead and recall
You
him.
did? Yes, bring him up.
Your Honor, may I approach?
Yes. All right. Mr. Neal, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth?
Zachary Scott Allen, Walter Button Neal, 08/31/1995.
All right. And Mr. Neal, you're here in 24 CF 2399, currently charged with possession of a controlled substance, third-degree felony, punished by up to 3 years in prison, and a no motorcycle endorsement charge.
Sir.
Okay. You can put your hand down, Mr. Neal. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with his advice?
Sir.
Are you under the influence of anything right now? All right. Any mental health issues or concerns?
Sir.
Did anyone promise you anything in return for this plea?
No, sir.
Anyone threaten you with anything in order to get you to plea?
No, sir.
You understand that by entering a plea, you're giving up the right to a trial and all the trial rights that are listed on page 2 of your agreement.
Yes, sir.
You understand you're waiving all potential defenses that you may have.
Yes, sir.
You understand that this would make you a convicted felon.
Yes, sir.
All right. And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right. And what is your plea to the possession of controlled substance and no motorcycle endorsement?
Contest.
All right. I'll accept your no contest plea to both counts. Adjudicate you guilty, credit for time served, $615 in court costs, 90 days to pay those court costs. We'll need your fingerprints because it's a felony conviction, Mr. Neal, and you have 30 days to appeal. This does appear to be a guideline sentence based on the guidelines I'm looking at and signing right now.
Yes, Your Honor.
Anyone else? Mr. Maddox?
I do have a few, Your Honor. Just need to get some signatures for those. You have Mr. Geis. That is,
Yeah, I'm trying to get all the non-inmates done since the inmates are a little.
Devin Little. Holly Godwin.
You need time with her though, right? Okay. Ms. Rivers, do you have anybody?
Your Honor, mine are in custody.
Okay, I'm assuming the rest. Mr. Russell? You're
Mine are in custody too, Judge.
Okay, Mr. Crawford?
My gentleman's in custody, Your Honor.
Okay, Ms.
He is here, though. We can bring him back.
Yeah, he is here.
All right. Ms. Merrifield, who do you have?
I have an out-of-custody hearing that was going to take a long time, but it will not any longer. Thank you, Judge. Brandy Merrifield on behalf of Wesley Bertrand. Mr. Bertrand is present in 23 CF 2071. Judge, this was set on the state's motion to revoke bond for Mr. Bertrand. As the court is well aware, he does have a 23 case that's been going on for quite some time. I have now taken over both of those cases. We do have a tacit agreement. However, there are some logistics.
Tacit agreement.
We do. We do, Judge. I've got multiple prosecutors, and unfortunately, ASA Barrickman's not here today. But we do need to work out some logistics with the monitor, community control.
And
Mr.
moving back.
Bertrand does not live here locally.
Louisiana, right?
Louisiana, yes, sir. I have spoken with Mr. Berry, who's given me some advice, instruction on how we can do that. So we're just requesting the next miscellaneous date so that I can put all the pieces in place.
What is the 23 case on right now? Or it is on this docket, is it on another pretrial? for
I
April?
think the 23 case is set for 4/28, and the 25 case may be set for June.
Okay.
That sounds right to me, Your Honor, but I'm not positive.
And this is the case that we were set for trial with your predecessor counsel, Ms. Merrifield, and it was going to get continued. And then that's when the new warrant came out from something that happened over a year ago while he's been coming to all of these court dates.
Yes, sir.
So.
I took over after that.
I think, and that was my concern with the bond revocation, not that it wasn't warranted, but because he had been showing up for every single court date, I didn't want him to go back to jail just because some paperwork hadn't been filed for over a year.
Sir.
Yes, Your Honor.
Okay. So what would you like to put it on, the 4/28 date?
I'd rather not do a pretrial, considering our pretrials are quite voluminous. So if there's a miscellaneous.
All the dockets are voluminous.
I know. Trying, Judge. If there's a miscellaneous date, or we can schedule it another time and leave it on the 4/28 date, I just need, the court is well aware of all the checks and balances for a case like this. I just need to get all the players kind of on the same page, and then I can't always bring it in for an earlier court date.
Problem is, I don't have a miscellaneous date until May 29th.
4/28 sounds great.
I'm just trying to be real with the situation. We don't have as many miscellaneous dates as we go through that trial calendar, so we have so many other dates, we don't have that date. All right, so let's put both cases on for April 28th at 9 o'clock. We'll see you back on that day, Mr. Bertrand.
I just want to say sorry for last time.
Okay, well, I'm glad you're learning.
Yes, sir.
And behaving yourself in the courtroom, so. All right, thank you,
That's all I
Mr.
have.
Bertrand, thank you, Ms. Merrifield. All right. Let's see what else we have. All right, Mr. Crawford, what do you have? You've got the,
We were. Mr. Randy Reedon, and we were.
in custody?
Yes, Your Honor. If you want to pass it, that's fine.
I'm not sure what order they're going to bring them up because we've been jumping so far back and forth.
At this point, I think we've got all
Okay.
We were. I'll wait for him to come out because this is substantive. Your Honor, Chris Crawford on behalf of Mr. Reedon. We were originally scheduled for a motion to suppress. And what occurred is, after some further investigation and discussions with essentially FHP's attorney, Ms. Pettit, and looking into these GPS issues, I have a very high confidence that I know where these individuals were. And this took, I want to put this on the record because I don't want this to be an issue on the other end of why was the motion not sought. So I have very high confidence I know where they were. This took a day, literally a day's worth of work of having to go through Google Earth images from different time periods whenever that Google car drove by trying to figure out. But I'm very confident I know where they were, and where they were was still within the modified construction zone.
Okay.
So
And the issue is that it was a excessive speed in a construction zone.
Correct.
He was allegedly doing 72 and what would have been a 60?
That's correct.
Okay.
And the what brought it down was the modification or the temporary, and I don't want to say temporary, I think it went on for many years, the construction work that was done.
As everyone knows, in northern Okaloosa County, construction projects can take a very long time.
Yeah, well, at least it's growing, right? But I wanted to put that on the record because at this point, after doing the investigation, it's not, we don't have the factual support to move forward with the motion, so we were drawing it. Nonetheless, we do have a resolution to the case as a whole.
Okay, well, let me, if he was doing 72 and the normal speed limit was 70, although I don't think he can be issued a ticket, he can be pulled over and given a warning for that. couldn't he?
Absolutely. So if he's violating the speed, he could be pulled over. There may be some variance of what the reader was to what the speed was.
Okay.
But clearly none of that matters if it's a 60. We're still.
Well over at that
Yeah,
point.
12 over. And where these individuals were was important to me because.
The individuals, you mean the FHP interdiction
Yes.
people?
Right. The individuals, the troopers who came up from Tampa. Just figuring that out because where I'm confident they were, and I can show the court, I have pictures of.
I don't need to know, I just want to make sure all these things are on the record for
Yes.
purposes of
Correct.
why you're not going forward.
Correct. Where they were was the very tail end of that modified speed zone, the 60-mile-an-hour speed zone. So where they observed Mr. Reedon was still in the zone. Where they ended up stopping him was actually outside where the speed limit would have changed. But where I know they were, and clearly now that I know where they're at, it makes sense that they're looking what is essentially eastbound and not westbound, because the westbound would be going at the higher speed. That all is the reasons why we are not moving forward with the motion.
And you have a resolution, you
We
said?
do.
And do you have that written up?
We do. May I approach?
Bring it up, sure.
It's going to be a plea to an amended count. Charging information, though I have gone over the charge that he will be pleading to with Mr. Reedon, including the minimum mandatory sentence that comes with it, the fine, the maximum penalty, and I did write down the actual statute number in the plea agreement, so it could be referenced and notated in the docket or by the clerk if needed.
So it's a plea just to the new count 9?
Correct.
That's correct, Your Honor, and I've instructed our office, and I apologize standing in. So out of all of the substances that are alleged, what actually came back from FDLE was not a single substance that is alleged. And so it ended up being where we're going to have to file an amended information, which I think if the defendant is doing this in writing, we should be able to file it. I'll obviously
And
send
we-
it to Mr. Crawford, but that is where we are.
And we're aware, and we communicated that to Mr. Reedon.
So you're saying he was charged with trafficking in fentanyl, cocaine, phenethylamines, codeine, sell, manufacture, deliver cannabis. All those substances came back as not what they were supposedly.
There's issues with testing, with getting FDLE to test more than one substance. We are having issues going through all of that. So what we have as evidence, if we were to move forward to trial, is methamphetamine, 14 to 28 grams. And that's why we're going to file on an amended count 9.
And that's the 5 years with a 3-year amendment. Okay.
And the phenethylamines is what was in reality the methamphetamine. And candidly, this does happen where the officers are dealing with pressed tablets, and they may believe it's another substance, when in reality it's just methamphetamine in pressed tablet form. They may think it's MDMA or something else. That's essentially what happened.
Interesting. All right, Mr. Reedon, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your full name and date of birth, please?
Reading, 08/07/1996.
All right, Mr. Reedon, did you have anything else that you wanted to say about the issue with the motion to suppress? I mean, your attorney explained it. I think I understand what's going on with it. I just want to give you any concerns about that at this point. All right, you can put your hand down. All right, so Mr. Reedon, in 23 CF 2713, the plea and sentencing agreement calls for you to plead to an amended information charging you with trafficking in methamphetamine, 14 to 28 grams, which is punished by as a first-degree felony, up to 30 years in state prison. Do you understand that? Do you understand there's a mandatory $50,000 fine? And the agreement that I have between you and the state, due to the issues with the testing that was just talked about, is for you to enter a plea just to that count. Adjudicated guilty, 5 years Department of Corrections, $50,000 fine. 3 years of that 5 years will be served as a minimum mandatory. Credit for all time that you've previously served on this case. That you'll have a driving license suspension for 6 months due to this being a controlled substance charge. And I don't have guidelines, but you're telling me the guidelines.
Yes, sir. And
They're written here, but I don't actually have them.
Yes, and we would agree that he scores out to
61.8 points.
61.8, and that
Which would get you to 25.35 months as a minimum sentence.
Yes, Your Honor.
But you're doing more than double that.
Correct.
Okay, so it's a guideline sentence, but obviously those will need to be filed with the amended information. Is that what your understanding is, Mr. Reedon?
Yes, sir.
All right. Is that what you want to do today? Okay. Did you go over this plea and sentencing agreement with your attorney, Mr. Crawford? Did you understand it? Did you sign it?
I don't believe he did.
No, he didn't. If you could. Yes, sir. Thank you. All right, so Mr. Reed, now you've signed the agreement, correct?
Sir?
Yes, okay. Are you satisfied with your attorney's advice and representation in this case? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to accept this plea? Has anyone promised you anything in order to accept this plea? Do you understand by entering a plea to the one count of trafficking in methamphetamine that there won't be a trial on any of these charges? All right, and it's the state's intent to dismiss 1 through 8?
That is correct, Your Honor. Cross on those counts.
Okay. And do you understand that you're giving up your rights to a trial that are listed on page 2 of the agreement that you've signed? And do you understand that you're waiving any potential defenses that you may have? And do you understand that by entering this plea, if you're not a U.S. citizen, you could be deported? Do you have any questions before I accept the plea?
Can I speak?
Sure. If you'd like to, I'm not asking you to.
Court, thank you.
I think that's good.
I learned from my mistake. No, that's it. That's all I want to do.
All right,
Give
thank you,
glory to
Mr.
God, too.
All right.
That's it.
Thank you, Mr. Reedon. All right, so how do you plead to the amended information to be filed in trafficking in methamphetamine, 14 grams to 28 grams? I'll accept your no contest plea as freely, voluntarily, and knowingly given. State has entered a no process into the counts 1 through 8. For that trafficking charge, it's going to be a 5-year Department of Corrections sentence with a 3-year minimum mandatory, $50,000 minimum fine to be imposed. You'll receive credit for all time you've served in the county jail pending this case. You'll have a 6-month driver's license suspension based on this being a trafficking charge. It's my understanding that won't start until you're released. But make sure you work with the DMV. Things may be different tomorrow. And this was a guideline sentence, was 25.35 months. The plea is to 60 months, so obviously it's a guideline sentence. Anything that I've missed?
And if you want me to announce the credit, it's $491.
Okay, I think the jail determines that. If there's any issues with that, you can certainly bring that to the court's attention. All right, Mr. Reed, you're going to have to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court. All right, thank you, sir.
Thank you,
Mr. Crawford.
Go ahead, sit down. Thank you. Absolutely. Receive it.
Okay, who did I have for the bond remission? Is he still here? Did he disappear on me? Yes. Okay, I'll recall him when he gets back. I just had to read some notes that were being sent to me. So bond remission, I just think there was an error on the order. I wanted to make sure it was corrected before I signed it. I didn't have a order I could, yeah, I remember him being here, so. Just sign the order. Well, the order is correct, so. Well, I've just received a note that he said he had to leave. He's told my office, so.
Tell him to hold on.
Well, he gives me a correct order, we can talk about it. Mr. Cobb. Mm-hmm. That's why we ask for Word documents as order, so I can change them when I need to change them. Send me a PDF, I can't really do anything with that.
Judge, this is State of Florida versus Trace Marshall, 2019 CF 1607. We're here for, I guess, just like a status review. I've talked to the state, and I'm going to request that this be passed to 4:30. His substantive charges are on the pretrial for 4:30. I've done a lot of research, and I still don't know the answer to the question, but I think I understand that if it's going the way you were suggesting, you could give him up to 20 months more DOC subtracted from the.
So, my notes, so I try to figure out day for day what you've done, Mr. Marshall.
Sir.
But also the issue was, I've done the research, I've talked to one of my colleagues who is in a criminal division as well, just to make sure I can be wrong. That's why we have district courts of appeal. So I always like to make sure I'm right, especially when someone challenges me on something I just think is something the way I've done it forever. So I want to make sure that we're doing it right. So, Mr. Marshall, I've done the research. Mr. Cobb, I've done the research. This is what we would call a true split sentence, which means you're sentenced to a period of incarceration that's suspended based on a period of probation. Those things don't get added up in the way that was suggested a couple weeks ago when we were here. I don't have the cases in front of me. I think one of the main cases I was looking at is called State versus Lacey, or Lacey versus State, but it kind of spells out the 5 different ways that someone could be sentenced. I would consider this to be a true split sentence, which means you don't get credit for being on probation. That doesn't, as your day for day, doesn't knock off your suspended sentence. So basically what happens is the way I've read it in the case law, it's if you have a suspended sentence, it's basically the court has determined what it's going to give you if you violate your probation is the way it's. Now, as I stated before, I can give less than that number, but I wouldn't be willing to do that until we actually had a hearing where both sides put on evidence so I could hear about it and understand that. But since there's also a pending new law violation, typically we handle those together. Otherwise, there can be some discrepancies or differences in what the score sheet ultimately gives us, but depending on how those are done. So I just want to make sure that was clear. But I spent a lot of time on this too, Mr. Cobb, just to make sure. It's my understanding he's got about 878 days now as of today. Currently jail credit, which would be 29.23 months or so. So even if he got the 48 months, he'd still have another year and a half to go. Doesn't mean, again, I haven't said I'll give you that time, but we'd have to have a hearing where someone would have to convince me to do less than that, or just stick with the suspended sentence, which was done by a different judge before I was here, so I don't have any memory of your case as to why it was done that way. So that's why I have to make myself what's called familiar with the facts and issues with the case, so that I can properly make that determination. So it sounds like we want to put it on the next pretrial for purposes of potentially figuring out both together. Is that what I'm hearing?
Yes,
Your
sir.
Honor, we were considering a combined offer for both cases. That's what
Okay.
we had discussed.
All right, so we'll come back on April 30th at 9 o'clock. Mr. Marshall, obviously, if there's something to resolve that day, we can do it. But again, in order to have me do less than that number, I just need more information so I can make that determination based on the factors as are required by law.
Yes, sir.
All right, anything else?
No, sir.
All right, then
And
we'll-
I did do the research as well, and you were correct. I was the one mistaken last time. So I told you I'd tell you if I found that out.
And I told you I would tell you if I thought I was wrong too. But I always, again, I check with other people just to make sure, am I missing something here? Because although I did criminal law for 17 years before I took the bench, it's been 4 years since I've done it on this kind of level. So I want to make sure I'm not missing something. So
weren't.
I'm always willing to be told I'm wrong. Just don't
Thank you,
tell my
Judge.
wife.
All right. See you later, Ken.
Yes, sir. Thank you.
All right, thank you, Mr. Marshall. We'll see you back on April 30th. All right, Mr. Gilbert, sorry I didn't see you over there. Y'all have been kind of shuffling back and forth. Is this Stillman?
Yes, Your Honor.
Okay.
May we approach?
Yes, sir. Oh, both of you?
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
All right, go ahead, Mr. Gilbert.
Afternoon, Your Honor. Michael Gilbert on behalf of Charles Stillman in 24 CF 1819. He is present, and we have offered the court a plea.
Okay. All right, Mr. Stillman, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Stillman, in 24 CF 1819, you're charged with DUI manslaughter, which is a second-degree felony punished by up to 15 years in state prison and a $10,000 fine. There is a 4-year minimum mandatory sentence on such a charge. You're also charged on a third DUI outside of 10 years, which is a first-degree misdemeanor punished by up to 11 months, 29 days in the county jail and a $1,000 fine. Do you understand what you're currently charged with? All right. I've been handed a plea and sentencing agreement. What I've been asked by your attorney in the state is to accept your plea today and then set it for sentencing next week. And it's my understanding that would be Tuesday at 9 a.m. Okay. Any issues with that?
No, sir.
All right. Ms. Glisson, do you have, it's my understanding there's several members of the victim's family present. Do you need to talk to them about that date?
No, Your Honor, they've already indicated that date and time will work for them.
Okay, so an agreement's going to be made about sentencing today between y'all, but the sentencing will just be next week? Okay. All right, so Mr. Stillman, the plea and sentencing agreement I have calls for you to plead no contest as charged. In count 1, the DUI manslaughter, you be adjudicated guilty. You be sentenced to 11 years in the Department of Corrections, with that being a 4-year minimum mandatory, followed by 3 years of probation, a $2,000 fine, 6-month ignition interlock on any vehicle that you own, substance abuse course and psychological evaluation followed by any recommended treatment, no possession or consumption of alcohol or drugs without a prescription, lifetime driver's license suspension. I would order a restitution and reserve as to the amount of that restitution. Court costs on that charge. Can you give that to me? $683, and then a $100 cost of prosecution on count 2, which is the third DUI outside of the 3-year or 10-year period. It would be adjudication of guilt, 11 months, 29 days probation concurrent with count 1, so that would begin once you're released from the Department of Corrections. Is that your understanding of the agreement, Mr. Stillman? Is that what you want to do? Okay, do you understand I would accept your plea today, but we would set it off for sentencing on this agreed-upon sentence between you and the state for Tuesday, April 15th at 9 o'clock, based on their request? Okay. All right, have you gone over this plea and sentencing agreement with your attorney, Mr. Gilbert?
Yes, sir.
And did you understand it? Okay, did you have any questions about it now?
I don't think so, sir.
All right, do you need more time to speak with your lawyer about it? I'm not suggesting you need that, but when there's any kind of equivocation, I certainly ask the question if you need more time.
I don't think so, sir. I feel obligated to that.
Okay. Well, what do you mean obligated? Has someone pressured you into this in some way?
No, I feel as though I deserve what I've got there.
Okay. Did you sign the agreement? And if you had any questions about this agreement, did Mr. Gilbert answer those questions for you? Are you satisfied with Mr. Gilbert's advice and representation in this case? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you? I know I asked you that before, but I want to make sure I'm staying with my same kind of colloquy. Has anyone promised you anything in return for your plea? You understand by entering the plea to these charges, as charged, there won't be a trial of any kind.
Yes, sir.
Do you understand that you're giving up your trial rights, which are listed on page 1 of the agreement that you signed? Did you have any questions about those trial rights?
No, sir.
All right. You understand that you're waiving all potential defenses that you have to both the DUI manslaughter and the misdemeanor DUI by entering a plea?
Yes, sir, I believe so.
Okay, and do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And what I announced, was that the state's agreement?
It was, Your Honor.
Okay, and I'm looking at the guidelines that calls for a minimum lowest permissible prison sentence of 124.65 months, So basically, a little under 10 and a half years. This is a plea to 11, so it's above the guidelines.
That's correct, Your Honor.
All right, and Mr. Stillman, what is your plea as to the DUI manslaughter and the third DUI outside of 10?
Sorry.
What is your plea? Guilty, no contest, or not guilty?
Contest.
I'm going to accept your no contest plea as freely, voluntarily, knowingly given. I've reviewed the sentencing agreement between the two of y'all, the state and you, and we'll set it for that agreed upon sentencing date, which is going to be next Tuesday, April 15th at 9 o'clock. And that will be in person here. That's not on the, it might be a different courtroom. I have to make sure I've got a courtroom because that's not a normal date that but, typically this is what we use. So we'll see you back on that day. I've signed the plea. I'm going to file that with the guidelines. But I have not pronounced or issued the sentence yet.
Your Honor, if you could, the guidelines,
Yes.
the guidelines does require a date of sentence to be filled out. That's Mr. Gilbert's.
Oh, that's Mr. Gilbert's copy. All right. I'm going to give him that back. You'll file those on Tuesday. Okay. All right. Anything else that we have to cover for Mr. Stillman?
Nothing from the state, Your Honor.
All right, Mr. Stillman, we'll see you back on Tuesday, the 15th at 9 o'clock.
Thank you, Your Honor. That's all I have before the court may be excused.
Thank you.
Thank you.
That's it.
All right, you want me to start at the top?
So I have one more case.
Oh, you have another case. All right. Thank you, Mr. Stillman. What else did you have, Mr.
So I'm
Gilbert?
actually covering for Mr. Brad Stewart for Jackson Harrell, who's also incarcerated. May I approach, Your Honor?
Yes, sir. Covering a plea. Oh, pretrial. Okay.
Once again, Your Honor, covering for Brad Stewart with Jackson Harrell and 25 CF 33. He is present, and at this time, we're offering post-plea PTI.
All right, Mr. Harrell, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Can you state your full name and date of birth, please?
Jackson Colt Harrell, May 2nd, 2005.
Okay, Mr. Harrell, in 25 CF 33, you're charged with 1 count of interference with the custody of a minor, a third-degree felony punishment up to 5 years in state prison, and 3 counts of domestic violence battery. Each are first-degree misdemeanors, punishment up to 11 months, 29 days in the county jail. Do you understand that?
Yes, sir.
I've been given a plea and sentencing recommendation that would require, or that would have you pleading to each of those, no contest and sentencing being deferred in lieu of the completion of a pretrial diversion or pretrial intervention agreement, which I also have up here. Is that what you want to do today?
Yes, sir.
Okay. And the pretrial intervention agreement, have you gone over that?
Yes, sir.
And have you signed it?
Yes, sir.
Do you understand all the terms of the pretrial intervention agreement?
Yes, sir.
All right, which call for no contact with the victims in the case. I'm sorry, no no violent contact with Jennifer Harrell, Brianne Raybon, and Cheyenne White. Excuse me. You're to successfully complete or comply with the ECLC program or a similar program, complete batter's intervention program, which is a 26-week course, $150 cost of prosecution, are the terms of your pretrial intervention agreement that you'd be pleading to. Is that right?
Sure.
Okay. And you understand that if you can successfully complete the agreement, your case will ultimately be dismissed?
Yes, sir.
All right. Do you understand that by the fact that you're entering a plea in order to get into this pretrial intervention program, that if you were to not successfully complete the agreement, that I could sentence you up to the maximum for each of those charges?
Yes, sir.
Okay, so obviously you've got a lot of incentive to follow the agreement, right? Otherwise, it could be, 5 years on the interference and just under a year on each of those 3 domestic violence charges. Do you understand that?
Yes, sir.
Is that what you want to do today? Did you go over this plea and sentencing recommendation or agreement with your lawyer? Okay, now Mr. Gilbert's filling in for Mr. Stewart today. Do you have any concerns with that? Did you go over this agreement with Mr. Stewart already?
Yes, sir.
Okay. Did you understand the agreement?
Yes, sir.
All right, and you signed everything?
Yes, sir.
Okay, and you have, are you satisfied with the work of your attorney? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Are you, has anyone forced, pressure, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? Do you understand that by entering a plea, you be giving up your right to a trial and all your trial rights, which are on page 2 of the plea?
Yes, sir.
And do you understand you're waiving all potential defenses that you may have? All right. What is your plea as to the interference with child custody and 3 counts of domestic violence battery?
No contest.
All right, I'll accept your no contest plea. This will be a plea to, again, the pretrial intervention agreement, which is signed, and Mr. Barry, I think you'll need this. Yes. All right, leave that there, right there for you. All right, you're to complete the pretrial intervention program with the conditions I've previously announced. All right, anything else?
That's it.
All right, thank you, sir.
Thank you, Your Honor. That's all I have this afternoon.
All right, we'll see you back on Tuesday. All right, how do y'all want me to call them? Just start at the top and just bring them out and. Arnold Allen. Mr. Allen, you're here at 21 CF 967. I think we're here because of a return from the Florida State Hospital. Is that right?
Yes, sir.
Okay.
That's correct, Judge. He was returned from Florida State Hospital. I have met with him. I find that he has been restored to competency myself and would stipulate to the admissibility of the report from Florida State Hospital.
Okay, and I reviewed that report. It was dated, I believe, December 11th, 2024 was the filing date of that. Does the state agree or stipulate to make the decision on competency based on the report?
Yes, Your Honor.
All right. So based on the report, I'll find that Mr. Allen is now competent to proceed.
Thank you.
What would we like to do with his case now that he's back?
Judge, I already reached out to the assigned prosecutor, Ms. Leone. Let's go ahead and set him on a pretrial conference date, and she's going to talk with the victim, see if we can get the case resolved.
You want to put it on that sooner one to April?
Actually, Judge, yeah, I think, I don't know how much time she'll need to contact her, but she's expected back relatively soon, right?
This evening.
Okay, so yeah, let's try to get it done that.
All right, April 30th at 9 o'clock for your pretrial conference, Mr. Allen. That way they can see if we can get the case resolved.
Okay, thank you. Now, Judge, I may be filing a bond motion for him.
Okay.
If I get that on a different date,
I would try to put that on a different date. I've got the next couple of Thursdays that we do pretrial detentions. We can maybe add on some minor things like that.
Yes, sir. So if Ms.
With
Leone
approval.
gets an answer, we may be able to resolve the whole thing, bring him in on Thursday.
All right.
Okay.
Thank you, yes, sir.
All right.
Thank you, Mr. Allen.
You have a good day.
You too.
Thank you, sir.
Gladys Chansey? I thought we handled all the out of custody. I guess I was wrong. I don't even have her on my list.
Charles Russell, Public Defender's Office. Judge, this is Gladys Chansey. Case number for the record is 2016 CF 1505. I had filed a motion to dismiss based on the fact that she's been found incompetent to proceed for 5 years, actually over 5 years. So that's what we're here on.
I was just filed a couple of days ago.
Yes, sir.
Your Honor, based on that, we're just requesting a continuance to look at it. Obviously, we need to reach out to the victim in this case and speak with them. Whatever the next court date would certainly give us plenty of time to do that.
And it wasn't even on my docket, so I hadn't even read the motion, Mr. Russell. I don't think I have anything before that May 29th date.
Okay. She is currently set for pretrial conference on April 28th.
Obviously, we can't do this kind of motion on that date.
Yeah.
If y'all talk about it and you've got some sort of an agreement, that's one thing, but those dates are obviously pretty lengthy.
What about did you say that you were going to be doing pretrial detentions the next couple Thursdays?
I do them every Thursday, but I can certainly add some things to them the next 2 weeks, but just make sure you clear my office first, because I've got the next 2 weeks are my civil trial weeks, and they're empty, but I've already started adding things to it now that everything is washed out. But I'm trying not to make it wide open so I can catch up on some things and make sure everyone is ready for those hearings, as opposed to trying to rush to it. So
I'm not available next Thursday. The next Thursday after that, the 24th, I'm just trying to avoid her dealing with the pretrial conference date.
we can put it on for 12:30 that day, just in case we have. I mean, it might be later than that, just because if we have any pretrial detentions that day. So I'm already covering a docket in Santa Rosa County the day before that, so that's why I've already started doing things like that to fill my days.
Okay. So April 24th at 12:30. Okay. Thank you, Judge.
April 24th, 12:30 for purposes of the motion to dismiss. Obviously, if something comes up where it's got to be changed, reach out to my office and make sure I know so I can prepare.
Yes, sir.
All right. What about Holly Godwin?
Yes, Your Honor, ready to go on that one. Matt Birch.
Godwin, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your full name and date of birth, please?
Jill Godwin, 2/17/89.
Okay. Can you pull that microphone a little bit closer to you? I can hear you, but if it's a struggle, then that means the microphone's probably not picking it up. All right. Ms. Godwin, you're here in 24 CF 2400, where you're currently charged with tampering with evidence, a third-degree felony, punishable up to 5 years in state prison, drive while license suspended, second-degree misdemeanor, punishable up to 60 days in county jail, and possession of drug paraphernalia, punishable by up to 11 months, 29 days as a first-degree misdemeanor. Do you understand what you're currently charged with? And I've been given a plea and sentencing agreement that would have you plea as charged. It calls for an adjudication of guilt, which makes you a convicted felon. Credit for time served. Court costs would be $515. Okay. And you'd have 90 days to pay those court costs. Does that include the PD fees? And so $150 for the public defender fee. Do you understand that? Is that what you want to do today?
Yes, sir.
Did you go over this document with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with his advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? No?
No, sir.
Okay, I saw you shaking your head, but I just got to make sure it's on the record. All right, did anyone promise you anything in return for this plea?
No, sir.
Anyone force, pressure, or threaten you in return for this plea?
Sir.
By entering the plea, you understand you're giving up your right to a trial on each of these charges and giving up your trial rights, which are listed on page 2 of the agreement you signed.
Yes, sir.
You understand you're waiving all potential defenses that you may have.
Yes, sir.
Do you understand that by entering this plea, if you're not a U.S. citizen, you could be deported?
Yes, sir.
All right, and what is your plea as charged with the tampering, driver's license suspended, and paraphernalia?
Guilty.
No contest.
Oh, no contest.
No contest. State's agreement?
Yes, Your Honor.
All right. I'll accept the no contest plea as charged, as freely, voluntarily, knowingly given, adjudication of guilt, credit for time served, $515 in court costs, $150 PD fee. You have 90 days to pay those, ma'am. You can probably set up a payment plan with the clerk's office if you just go down to the first floor and ask about that. They might not be able to do it today, though, because I don't have the paperwork. I'll need your fingerprints because it's a felony charge for which you're being adjudicated. You have 30 days to appeal the judgment and sentence of the court. This appears to be a guideline sentence based on the guidelines I have, showing this is as 21.4 points for
Yes, Your Honor.
0 months. All right, thank you.
Your Honor, I also have Devin Little, if you want to go ahead and call him.
All right, Devin Little.
Your Honor, this is Mr. Devin Little before the court in 24 CF 2133. Before I bring up the plea agreement, Your Honor, it's a written plea agreement. One thing I did want to draw the court's attention to is I do believe this is Mr. Little's first felony conviction. Therefore, a pre-sentence investigation report may be required. We are expressly waiving that requirement today for purposes of entering this plea agreement, Your Honor, and I have discussed that with Mr. Little.
Okay.
May I approach?
Thank you. All right, Mr. Little, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth?
Devin Walter Little, 09/30/98.
All right, and Mr. Little, you're charged in 24 CF 2133 with 1 count of possession of a controlled substance, 3rd-degree felony, and 2 counts of possession of drug paraphernalia, 1st-degree misdemeanors. Do you understand that?
Yes, sir.
This calls for you to plead no contest as charged, adjudication of guilt, credit for time served. That'll be, what, $615 in court costs and $150 to the public defender's office. You have 90 days to pay that. Is that what you want to do today?
Yes, sir.
Did you go over this form with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your attorney's representation?
Absolutely.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you suffering from any mental health issues or concerns?
No, sir.
Anyone promise you anything for this? Anyone force, pressure, or threaten you to do this?
No, sir.
You understand that by entering a plea, you're giving up your trial rights, which are listed on page 1? You understand you're waiving all potential defenses? And you understand that by entering this plea, you'd be a convicted felon, but also if you're not a U.S. citizen, you could be deported. Do you
Yes.
understand that? What is your plea?
No contest.
State's agreement?
Yes, it is, Your Honor.
Okay. I'll accept your plea of no contest to the possession of controlled substance and 2 counts of possession of drug paraphernalia. Adjudicate you guilty of each of them. Credit for time served, $615 court costs, $150 to the public defender's office. You have 90 days to pay those or make that payment plan. I'll need your fingerprints, and you have 30 days to appeal the judgment and sentence of the court. I have reviewed the sentencing guidelines. That calls for 21.2 points and 0 months possible sentence, lowest possible sentence. All right, thank you. Come up and be fingerprinted.
Thank you.
All right, thank you, Your Honor.
Thank you. Help Mount Kenny.
Judge, this is Herbert Atkins. Herbert Atkins, case number is 2007 CF 622. I believe we've worked out an agreement. Judge, if I could just have a moment. Can you?
They ain't doing nothing, just making a noise.
You able to hear me, sir?
All it's doing is making a loud noise.
Let me see this. How about this one?
It's just listen at it.
Yeah, all it's doing is humming at me. Well. Well, I don't know what's wrong with it, but it's not working. And it's a systemic issue.
What is the agreement?
So the agreement, Judge, is it's a violation of probation plea agreement. Originally, he had 2 counts. Count 1 was sexual battery, which was an F1. Count 2 was a L&L conduct, maybe, but it was an F2. Way back when, he was sentenced, he was given 15 years concurrent, so he can't be on probation for count 2 because he's already served the max sentence on it. So on count 1.
Already served 15 years of probation?
Prison. He got 15 years prison followed by 10 years probation on both counts, but technically he can't get the 10 years probation on the second count because he did the max in prison.
Max.
Yes, sir.
Incarcerative sentence.
Correct. And so what we've agreed to work out is if he pleads to the count 1 violation of probation, it would be an adjudication of guilt, reinstated, modify his probation, waive cost of supervision, serve 240 days in the county jail, credit for time served since his arrest on September the 12th of 24. And for purposes of today's sentence only, he would waive any credit prior to September 12th, 24. And then he would pay a PD fee of $150.
Can you hear that, Mr. Atkins?
Did you hear any of what I just said?
I heard part of it.
Okay.
Do they have someone on the way? Why don't we do this? Why don't we take
You read
about a
out my
5-minute
crime
recess
to
if
you.
y'all can fix that, and I can see if I can still walk.
Do you have any questions about
All right, we'll
this?
take about a 5-minute recess.
You got any questions about this?
Yeah, what is this right here?
Okay. This is the maximum jail sentence you can get is 30 years. The maximum fine is $15,000. But you just have to know what the maxes are. Any other questions about any of this?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
That's fine.
Or you can go ahead and go. All right.
We have someone else for that, right? Why don't we handle that one next?
Should be a couple of officers here. I know one of them's here.
Okay, Judge, this is Herbert Atkins, case number 2007 CF 622, and we have a plea agreement, if I may approach. And Judge, we would just ask that the minute sheet reflect that he's only going to be on probation on count one, not count 1 and 2.
How much more time on probation does he have?
He got 10 years, Judge, and he got arrested right after. Less whatever time.
So just reinstating the current time that he has.
Right, the remaining time.
Yes, so we would prefer to.
Okay. All right, Mr. Atkins, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Herbert Lee Atkins,
Date of birth?
1946, January 10th.
January 10th, okay. All right, Mr. Atkins, you're here in 2007 CF 622 on a violation of probation. I've been handed a plea agreement that calls for you to admit that you violated your probation. There'll be adjudication of guilt, reinstate and modify your probation, waive cost of supervision. You'd serve 240 days in the Okaloosa County Jail with credit going back to your arrest on September 12th of 2024. And that credit is for purposes of this sentence only. You'd also waive any prior credit prior to September 12th, 2024. Do you understand that? So
Yes,
basically,
sir.
you're doing 240 days of a sentence going back to September 12th.
Yes, sir.
Okay. Also, there'd be a PD fee of $150. And is there a VOP fee? I didn't see that. Is that $100?
Only $100.
$100 VOP fee. Is that what you want to do, Mr. Atkins?
Yes, sir.
All right. Have you gone over this agreement with your attorney?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
Beg your pardon?
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone promised you anything to induce you to plea?
No, sir.
Has anyone threatened you to get you to plea?
No, sir.
Do you understand by admitting your violation of probation, there won't be a further hearing where the state would have to prove to me that you violated your probation?
Yes, sir.
All right. What is his designation already?
Yes,
Okay.
it's based on the prior, Your Honor.
Okay, so Mr. Atkins, you've already been designated as a sexual predator. Do you understand that?
Yes, sir.
All right, so you still have to comply with all those rules.
Yes, sir.
All right. And what is your plea to the violation of probation? Are you admitting or denying?
Admitting.
All right. I'm going to accept your admission to the violation of probation. I'm going to adjudicate you guilty, reinstate and modify your probation, waive cost of supervision. You're to serve 240 days in Okaloosa County Jail with credit from September 12th of 2024. You're to pay a $150 public defender fee and a $100 VOP fee. And then obviously, again, the credit goes just back to September 12th. So he's still probably pretty close, right?
I figure he's over, Judge. I figure he should get out today.
Okay. All right. Is this a guideline sentence?
It is, Your Honor.
Okay. Or it's a modification?
It's a modification of the probation. It's also within the guidelines.
Can you modify a sexual battery charge? Okay. All right. So we'll need him fingerprinted, and then you got to talk to probation, Mr. Adkins, and they're going to fingerprint you. You've got 30 days to appeal.
Want them printed or here first?
Okay. Your Honor, Mr. Atkins is on GPS, so he will have to remain at the Okaloosa County Jail until we can.
Confined until the GPS monitor is put on.
And pay it $1 a day.
Thank you.
Yes, sir.
Judge Oberliesen, Mr. Atkins is my last case. May I be excused?
Did you hear that?
No.
They're gonna put a
You got to
GPS.
stay. You got to.
You and Sarah today. Double stress. I want ice cream.
Yes, that's why I wanted to call that next. Oh. Okay.
Be tomorrow, okay, tomorrow morning, probably.
We do.
Okay, so you don't have to worry about tonight, you're good for tonight.
Okay. Do you want to handle that order to show cause? Is that you, Mr. Williams?
Yes, sir, it is.
All right, let's get that one moving.
Judge, the case is State of Florida versus Michael Jackson.
What's the case number on that? I see.
4624 CF 58.
Come out there and see you at the jail, okay?
Judge, I filed the motion, and when I filed the motion, I attached copies of the return of service. Basically, I filed one motion on each of the two officers, even though there were two separate occasions that they were served, and each one of them was served and failed to appear in court. I believe Ms. Rouse was here earlier.
I think she's still here. Come on up, ma'am. Megan. I think the podium is fine. Yes.
Just as my own personal policy, I don't do an order show cause for missing one.
I think the
You know, that's just too easy
rule
to
says
have
that.
happen.
Okay.
But there was, the first subpoena was for depositions on December 18th, scheduled at 9:45 a.m. The sheriff's office received it for service on November 7th at 9:23 and executed the same at the same time. So apparently the person who received it was the actual officer that was responsible for receiving service. And that was signed by D. Rowley, radio number 2079. When she did not appear, we reset the deposition for Friday, January 31st at 9:15 a.m. Again, the sheriff's office received the subpoena on January 13th at 5 p.m. Executed same on January 13th at 5 p.m. Same D. Riley, radio number 2079. The court, I'm sure, is aware of the sheriff's office will sometimes designate somebody for receipt of services process.
Your name, ma'am?
Aaron Roush. Can you hear me okay?
I can hear you.
Okay.
Yes, ma'am. So it's my understanding that you were served twice for deposition and did not appear.
Yes, sir.
What this is an order to show cause hearing where I'm ordering you to show cause as to why I shouldn't hold you in contempt for missing two depositions when you've been served. If you have a defense to that, you can certainly tell me what that is.
Yes, sir.
But, you know, this is obviously a pretty serious matter that's delaying a pretty serious case. So what would you like to tell me?
Yes, Your Honor. I brought paperwork with me from October 11th of 2024 to January 27th of 2025. I was on and off of FMLA. I got the flu first, which turned into bronchitis, which turned into a serious case of pneumonia. after I got pneumonia the first time, I tried to go back to work. I ended up in the hospital. I got pneumonia again, and I was out of work December 23rd is when they put me on FMLA the second time, until January 27th was my first day back at work. But I ended up having to resign from my position as a deputy due to the illnesses that I was having, because I just couldn't perform the job functions anymore. At that
I guess my
point.
point, do you know why they would continue to accept subpoenas on your behalf if you were on leave?
The way that it had been explained to us, I don't remember when, I'll be honest, but at some point last year, the sheriff's office indicated that they were no longer allowed to not accept subpoenas on our behalf, because it goes against, I don't want to misspeak.
Sure.
All I remember them saying is that there was a statute that indicated that they were not allowed to not accept them for us for any reason.
Judge, I've been told in other matters that, well, I'm sorry, we need at least 10 days to serve the subpoena.
That's definitely a rule that they'll enforce. My concern, if they're being served more than 10 days out and someone's on leave, they're just accepting the subpoenas and no one shows up because she's not even there to receive the subpoena. Because my understanding is they just put it in their box or whatever when they go in on their next shift. They see it and they know to go to the deposition. But if she's on leave for weeks at a time.
Yes, sir. Obviously, I'm not asking to have her incarcerated or anything like that, but if she's going to be a witness on the case, I need to get her in a deposition.
Can I say something?
Yes, Ms. Rush.
First of all, I want to apologize to you. I would never willingly not go to court. That was my first trafficking case ever, so it's important to me. So I do apologize to you for making you go through all this extra work. That's all I wanted to say.
Okay.
You don't have to apologize to me, ma'am.
I
It's
just,
okay.
Well, part of the reasons that we have these hearings is to find out what happened. And now it sounds like we're finding out something that's a little bit concerning, and it's how things get handled. And I'm not sure what the change in the statute was.
I don't know.
But
If I can inquire just to make sure that I'm understanding it, so when you came back on the 27th, you weren't told that you had a depot schedule for the
31st.
No,
31st.
the way that the sheriff's office handles it is they send us an email with a subpoena attached to it. I'll be honest, I was off for 3 months. I checked my email yesterday, I had over 4,000 emails that I've had to look through, and it's a lot to come back to. Not only I was still on a lot of medication and I wasn't feeling well, I just had way too many emails to look through, and I think they just slipped through the cracks.
Ms. Rosh, since you're no longer with the sheriff's office, can you provide contact information to Mr. Williams in the state attorney's office so they know how to get in contact with you?
I am still employed just as a civilian now.
Oh, okay.
Yes, sir. I just had to give up my sworn position with the sheriff's office until I get better.
All right, we'll try to get it rescheduled, and ma'am, if you'll keep an eye out specifically for that email.
Yes, sir. I can do that.
Well, based on what you've told me today, Ms. Rosh, I'm not going to find you in contempt. I don't think there was a willful violation of the subpoena. Might need to be some discussions down the road on how we can make sure this doesn't happen again. I tell you, that was my pet peeve when I was a lawyer, is getting all prepared for things and people don't show up, and it turns out, even though we served, they didn't even know. It's a very frustrating part of this, especially when we're trying to resolve these cases in a timely fashion. Defendants have a right to speedy trial. Victims have a right to a speedy trial. We got to make sure that we're just all doing a little bit better at this. But
And ma'am, generally, I can accommodate you with a Zoom or phone appearance or something like that.
Okay.
I'm one of the easiest people you'll ever meet on that.
Thank you.
All righty.
all right, thank you, Ms. Roush.
Judge, I had
Or the
another
other
one
person?
scheduled on a Richard Edward Morris. Is Mr. Morris in the courtroom?
Was he served? I know I didn't sign the orders until.
That I do not know, Judge.
Looks like she was served. I don't see anything for him. So we might just have to redo that, Mr. Williams. Was he sheriff's office as well? Because a different.
Yes, sir. Yeah, same dates and times.
Deputy?
I believe so.
I don't recognize the address, and I don't want to blurt it out in open court when it's.
Well, I say that. Hang on just one second. I did receive notice of somebody that was no longer with the department. And that may have been Ms. Roush. I was thinking it was Mr. Morse, but it might have been Ms. Roush.
Well, why don't you take a look at it, and if you want to get it rescheduled, we can certainly do that. But we've got to get these depositions moving.
Yes, sir. Yes, sir. Looking at nope, he was a civilian, 663 Brunson Street was the address that he had, but he was a Category A witness.
Okay. So, but he's not with the sheriff's office.
Does not appear to be, Judge.
All right. Well, let's get him served for another order to show cause. If you want to send one of those over to me, let's give it a little bit more time so we can get him here.
Yes, sir.
Why don't we get back to our list? Ansley? Is that with an A? I assume we're looking at the same list.
Madam Clerk, do you have any exhibit stickers?
Here it is. All right. This was competency.
Judge, this is Levon Ansley. Case number for the record is 25 CF 35. We had set two things for today, a competency hearing and also a bond hearing. I believe the competency issue may resolve the case. If I may approach.
Yes. Oh, okay, thank you.
I'd like to file Defense Exhibit 1, which is a report from Dr. Zeman. I provided previously copies to the state. We'd ask that the court order that it be sealed also. In that report, Dr. Zeman concludes that Mr. Ainsley is incompetent and also unrestorable. His report refers to a prior evaluation where he reached the same conclusion, and that was in Mr. Ainsley's prior case, 21 CF 2089. So we're asking that the court today find him incompetent and unrestorable.
No objection from the state, Your Honor.
The state stipulated I can make the determination based on Dr. Zeman's report.
Yes, Your Honor.
right, based on Dr. Zeman's report, in which he references not only his previous report in 2022, but Dr. McDonald's previous report in 2022, that he's finding that Mr. Ansley is not only not competent to proceed, but also unrestorable due to his neurodevelopmental delay. And there's basically no treatment that could be provided that would ultimately restore him to competency. I'll find that he is not competent to proceed, and also that he's non-restorable according to the report.
Your Honor, based on your finding, the state is going to dismiss 25 CF 35.
All right, case is dismissed.
Dropping your case, so you should get out, okay? Okay.
There's like two different 2 o'clock dockets, and they're like, at least that's the way I got them. So I'm just like flipping back.
No, not at this time.
Like alphabetically, there's like if you look
about that though.
Yes, sir. Report's not. There's one 2 o'clock docket that has 8 things on it, another one that has 25 things on it. So we're just seeming like bouncing back and forth. It's usually like if it just says 2, and some will say like 2 to 2:15, like it'll treat them differently. All right, this is Mr. Hartley.
Yes, Your Honor.
Go ahead.
This is Mr. Randall Hartley, Your Honor. It's set for status today. Effectively, the state wanted to make communications with the officer, see if that would change anything. Things have certainly changed from a case perspective. In the positive direction for Mr. Hartley. It will change his score sheet. It's going to bring that down some. I'll certainly go to the jail and talk to him about these developments. We're not prepared to enter a plea today, Your Honor. I would just ask, based on these developments, that we continue this to the pretrial conference in April to see if we can't work something out by then.
It'll be April 30th at 9 o'clock.
Thank you, Your Honor.
We'll see on that day, Mr. Hartley.
Next I have Mark Lambert.
Your Honor, we've reached a resolution in this matter. I'm just going to have Mr. Lambert sign. I'll date it for you. Your Honor, may I approach?
All right, Mr. Lambert, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name and date of birth, please?
Mark Harding Lambert, 11/12/67.
All right, Mr. Lambert, you're here in 24 CF 2787, charged with burglary of an unoccupied structure, third-degree felony, punishment up to 5 years in state prison, and petty theft, punishment up to a year in county jail. I've been handed a plea and sentencing agreement that calls for you to plead no contest to both cases. In count 1, the burglary be adjudication of guilt, 11 months, 29 days, Okaloosa County Jail with credit for all time served. Court costs, no trespass at local DRIP.
Yes, that's the establishment.
Okay, and comply with the ECLC program while you're in the jail. And count 2 would just be adjudication of guilt and time served. Is that what you want to do?
Yeah.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes.
Did you understand it?
Yes.
Did you sign it?
Yes.
Are you happy with your lawyer's representation in this
Yes.
case?
Yes.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No.
Has anyone promised or threatened you regarding this plea agreement?
No.
Do you understand by entering a plea, you're giving up your right to a trial and all the trial rights on page 2 of the agreement you signed?
Yes.
Do you understand you're waiving all potential defenses?
Yes.
Do you understand that if you're not a U.S. citizen, this plea could subject you to deportation?
Yeah.
And do you understand you'd be a convicted felon based on this?
Yes.
And what is your plea to the burglary of an occupied structure and petty theft?
No contest.
I'm going to accept your no contest plea. It's freely, voluntarily, knowingly given. State's agreement?
Yes, it is, Your Honor.
All right, count 1, adjudication of guilt, 11 months, 29 days, Okaloosa County Jail with credit for all time served. Court costs will be $515, $150 PD fee, $100 cost of prosecution, no trespass at the local DRIP, comply with the Emerald Coast Life Center program while in the jail. Count 2 is an adjudication of guilt and credit for time served.
It is a downward departure based on negotiated plea, Your Honor.
Okay, do y'all have a score sheet?
I don't know if I have one for this one.
If not, I should have one, Your Honor.
All right.
Yeah, I got one.
So departure based on uncoerced plea agreement between the state and the defendant.
Okay.
All right, Mr. Lambert, we need you to be fingerprinted, and you've got 30 days to appeal. Thank you, sir. All right, what are we doing with Ms. Proctor?
Your Honor, I believe we're here for a competency evaluation today. For Ms. Proctor, I have received a report back with respect to Ms. Proctor. It's recommended she be found competent to proceed. Discuss the report with the state. I do believe they're willing to stipulate to admission of this report.
You are, Your Honor.
Okay.
No, thank you.
And I've previously read the report that was filed on March 18th of 2025. That was done by Dr. Neville. This is coming straight from the based on that and the stipulation, I'll find that she's competent to proceed.
Thank you, Your Honor. The state did make her an offer today, Your Honor. If we could just pass her briefly, I will advise her about it and see if she wants to take it. Otherwise, if we could just set her for the pretrial conference date on the 30th.
All right, I'll put it on April 30th at 9 o'clock, but if you figure it out, just recall it and we'll resolve it today.
Okay, perfect. Oh, one other thing, Your Honor. I know that there's not a bond motion filed in this case, and forgive me for raising this matter. I was just looking at her bond history. She did initially have signature bonds on each of her counts. She's now been found competent to proceed. I don't believe this is a situation where she's violated or anything. I don't know if it's routine that she's held in the jail pending resolution, but she has been found competent to proceed. Now, if the court was willing to consider it, or if the state were willing to agree to the bond being reinstated.
And if I may, Your Honor,
Go ahead.
as a friend to the court, as someone who used to represent her, Your Honor, she posted bond, she came to every court date. It was only after she was found incompetent that Judge Monteric ordered her into custody for purposes of being transported to Florida State Hospital. So I would argue that she should be released. The other thing is, Your Honor, I had contacted the psychological provider that we contract with regarding any services upon her release, and to try to get it done, see if we could get it done in advance. And she indicated no, that could not and would not be done. She said after today's hearing, she would, if asked to do so, that she would make recommendations regarding services. So I would ask, Your Honor, that she be released.
I'm looking on, there was a motion to reduce bond on June 27th of 2024, where where Judge Gonteric made it $1,000 signature bond on all counts. Those were posted, and she was found incompetent to proceed in October while she was on bond.
No objection to reinstating the bond, Your Honor.
All right. Bond's reinstated, signature bond.
Okay, but we'll have to talk about a plea if you want to still plea or not. No, if she's being released, I can talk to her.
Well, let's put her,
Make sure
hold
you
on, let's
reach out.
put her on then the different April date if you want to
Oh,
do
the 28th, yes, Your
April
Honor.
28th at 1 o'clock, since she's no longer incarcerated.
Give me a call, okay?
I will, first thing when I get out.
Okay.
I want to keep you. So. Start all over. I just had a mint. 1 o'clock.
Thank you.
I appreciate it.
Okay.
All right, who do we have next?
Mr. Reynolds.
Your Honor, this is Gerald Reynolds before the court on 24 CF 1238. We have reached an agreement in this matter. This is going to be your copy.
12.1 when he scores 12.9, so it's a downward departure of 0.8.
Yes, Your Honor.
All right, Mr. Reynolds, can you raise your right hand? Do you swear or affirm that the testimony about to give us the truth, the whole truth, and nothing but the truth? Can you state your name and date of birth, please?
Harold Reynolds, 3/14/88.
Okay, Mr. Reynolds, you're here on a violation of probation, 24 CF 1238. I've been handed a plea and sentencing agreement that calls to revoke and terminate your probation on counts 1 and 2. The sentence is going to be 12.1 months Department of Corrections concurrent with credit for any time served. Count 3 will be credit for time served because that was only a misdemeanor. And then $100 cost of prosecution, $100 PD fee, $50 application fee. Is that the agreement that you've struck? Did you go over this agreement with your lawyer? Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Is this the state's agreement, the downward departure by 0.8?
It is for a negotiated plea agreement.
Okay. All right, and Mr. Reynolds, are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Oh, yeah.
Are you currently suffering from any mental health issues?
Yes, sir.
Has anyone threatened you or promised you anything in return for your plea? Do you understand by entering an admission to your violation of probation, there won't be a hearing where they have to prove that you violated your probation? All right, and do you understand that this plea could subject you to deportation if you're not a U.S. citizen? And what is your plea, admitting or denying your VOP? All right, I'll accept your admission to the violation of probation. Counts 1 and 2 is going to be 12.1 months DOC concurrent with credit for any time served. Count 3 is credit for time served alone. $100 cost of prosecution, $100 PD fee, $50 application fee. And you'll need to be fingerprinted, Mr. Reynolds. And you have 30 days to appeal the judgment and sentence of the court. Thank you, sir.
Thank you.
Your Honor, outstanding monies to collections.
Yes, sir. All outstanding money to collections. It's bond.
Good afternoon. Good afternoon. I'm going to ask you some questions. Your Honor, before the court is Nicosi Seals on 24 CF 877. Mr. Seals is charged with violation of probation. He currently has no bond on the charge of violation of probation. I would like to take some testimony from you.
All right, Mr. Seals, raise your right hand. Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right.
Would you please state your name for the record?
Nicosi Seals.
Mr. Seals, do you have any children?
Yes, sir. I have one son.
Okay. And who has custody of that son?
I do, but he's in the care of my mother right now while I'm in jail.
And how old is your son?
6 years old.
All right. Do you have any type of employment, Mr. Seals?
I work at Pick and Save and Thrifties here in Crestview.
And, sir, how long have you lived in the Crestview area or in Okaloosa County?
I'm raised here. My mom, she became the assistant principal up here about 10 years ago. So I've been here for about 16 years now.
Are you asking the court to give you a bond, grant you a bond, an ROR, signature bond, or a cash or professional bond not to exceed $2,500?
Yes, ma'am, or an ankle monitor. Just want to take care of my child.
And are you concerned about him having to go into foster care if you're not able to post bond?
Yes, ma'am.
Those are all my questions.
Anything from the state? Anything else?
No, Your Honor.
Mr. Berry?
Your Honor, I supervise Mr. Seals, and what he has relayed to the court is the truth. The only thing that we got in a bind about, if you will, was he's a violent offender of special concern. I don't have any problem putting him back on community control. Like I say, he was doing everything like he was supposed to do up to the point that he went to jail. And he had done that for, I don't know, 6, 7, 8 months, maybe?
Oh, no, he pled on November 4th and was arrested in March.
So,
I'm showing at his plea agreement, he pled to community control followed by probation when he scored 23.475 months. So we got a downward departure to probation. And now this probable cause has been found that he's committed a new law while he's been on that probation. And the underlying, one of them on his VOP is fleeing to elude. Further argument, Ms. Rivers?
Your Honor, he is a violent. Based on that, to stay in place.
I agree. So, Mr. Seals, based on your history, you're designated what's called a felony violent offender of special concern because you're on probation and have a qualifying offense. So I can't give you a bond. I'm not sure what y'all are going to do to resolve the case. I'm not suggesting one thing or another, but I'm a little concerned there's been a downward departure and we're here again. So I'm going to deny your motion to set bond. I understand your concerns about your child, but you've got a pretty extensive history going back to your delinquency days. So if you're really truly concerned about that, then it's time to choose a new path. But you'll remain incarcerated while this case is pending. And again, this is not I don't think I have discretion to do that at this point.
Thank you, Your Honor. So,
Motion's denied. Who are you here? Are you on Falk, Micah? You want me to call? The problem is you're sitting right behind Mr. Sheik, so I can't see you most of the time.
Your Honor, my head is not that big.
Not that big, huh?
Falk, if we can do him next, then.
I'll be back out to see you, okay?
You ready on that one, Mr. Russell?
Yes, sir. Charles Russell, Public Defender's Office. Judge, this is Sean Falk. Case number for the record is 23 CF 1946. If I could just have a moment. So Judge, what we're here for today is this case went up on appeal. Public Defender's Office in the Second Circuit filed a motion to correct sentencing error. We set that for a hearing today. I talked to Ms. Herndon. The state's going to concede the motion, and as I read it, there were basically three grounds. They wanted count 2, which was a misdemeanor that was sentenced to time served, taken off the score sheet. They wanted the state to prove the prior record. The state's agreeing to take those off the score sheet, and so they're going to give a new score sheet today that scores him out to 25.5 months DOC. And then the last issue was...
What was the number again? 25?
25.5 months DOC.
Okay.
I think it was like 30-something. And the last issue was that the revocation order suggested that Mr. Falk had admitted the violations. That's incorrect. There was a contested evidentiary hearing, so I believe if all three of those issues are addressed, then we're good.
Are y'all stipulating to the sentence of the 25.5?
We are, and I have a brand new score sheet. It is inked up.
Because the problem with it I was concerned about is it wasn't me that gave that sentence. So just because there's a lesser score sheet doesn't mean, I don't know what Judge Gontarik's, why he gave the guideline sentence, if that was just a sufficient number, or if this had been 25.5, would he have given you 25.5? I don't know, but if the state's stipulating to it, I think we can resolve it.
Your Honor, there was one additional thing. I let Mr. Russell know. There is a cost of transportation, which I guess would probably just go to collections, but it is $65.40. And that is to the Okaloosa County Sheriff's Office.
Okay. All right, so based on the updated score sheet, I'm showing 25.5 months, and the state stipulated to that amount as well.
And we have no objection to the new score sheet, Judge.
Okay. And then are you going to get me an order on the stipulation, or I just want to make sure it's cleaned up for the DCA purposes?
That was, I don't know what to do about that. I didn't know if the clerk or probation or somebody submits an amended revocation order and changes the amount of time. I just don't know how logistically how that works.
Yes, I'm being told by the staff attorney that's what we need to do.
Okay.
Thank you. 2 thumbs up. Oh, so you're going to handle that order? Okay. Perfect. One less for me to write.
Okay.
She's been waiting all day.
And then if that order could also say that it wasn't due to a plea, it was a contested evidentiary hearing, then, and if you want to, do you want to add the cost of transportation to that?
Since I have brought this piece of paper, yes, I can give you this.
Expensive Uber. So.
It's perfectly fine. It's only $65.
Yeah, but my concern was since I wasn't one that made that decision, I wouldn't know how to change it unless we went through basically another sentencing hearing. But since the state's agreed to it, it makes it a little easier just to make it the 25.5 that you score. All right. Anything else for Mr. Falk?
No, sir. And he's housed in Santa Rosa in the CI over there, so he's good to go back.
Okay.
Yes, sir. I sign work release next week.
Oh, there you go.
Thank you very much. Hey, y'all have a
Thank
blessed
you.
evening.
You too.
Judge, this is Jimmy Council. Case number is 24 CF 2765. If I could have a moment, I believe we have an agreement. Jimmy Council right there. Sign it. Judge, may I approach?
Yes.
Possession of forged notes. All right, Mr. Counsel, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Jimmy Counsel, 12803.
03. All right, Mr. Counsel, you're here in 24 CF 2765, where you're currently charged with possession of forged notes, a third-degree felony, punishable up to 5 years in prison. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that calls for you to enter a plea of no contest as charged, withhold adjudication, 24 months probation, waive cost of supervision, 515 court costs, $150 PD fee, 50 hours of community service, work or buy that out at $10 per hour, and then maintain gainful employment or submit 2 job applications per week. Is that the agreement that you've made?
Yes, sir.
All right. Did you go over this agreement? Is that the state's agreement?
It is, Your Honor.
Okay. Did you understand the agreement?
Yes, sir.
Did you sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's advice?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances? Are you suffering from any mental health issues?
No, sir.
Has anyone promised you anything or threatened you in any way to get you to take this plea? Do you understand by entering a plea there won't be a trial of any kind and you're giving up your trial rights, which are listed on page 2 of the agreement you signed?
Yes, sir.
You understand you're waiving all potential defenses? Do you understand that if you're not a U.S. citizen, you can be deported based on this plea?
Yes, sir.
And what is your plea to the possession of the forged notes?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Withhold adjudication, 24 months probation, waive cost of supervision, 515 court costs, 150 PD fee, 50 hours community service. Can buy those out at a rate of $10 per hour, maintain gainful employment, or submit 2 job applications per week. Cost of prosecution, I think we missed. It's included in the 515? Okay, I thought you told me that too. Never mind. All right, so Mr. Counsel, you're going to have to talk to probation, and you have 30 days to appeal the judgment and sentence of the court. I have looked at the guidelines. They do show us a total of 10 points and a 0-month lowest permissible sentence, so this is a guideline sentence.
Judge, this is William Flanagan. For the record, case number is 23 CF 2730. We had set Mr. Flanagan's case for a competency hearing. Both the competency reports have been filed. I believe you can find them both in about September of 24. One's from Dr. Zeman, one's from Dr. McDonald. Both the reports agree that he's incompetent and unrestorable, so we're asking that the court make a finding to that effect.
He hasn't been found incompetent before.
I couldn't see one. I didn't see where he had been set for a competency hearing before, but
We couldn't find one either, Your Honor.
I would love to be
Reports are
corrected.
From when?
September of 24, Judge. McDonald was a court order one, and Dr. Zeman was one of ours that we filed.
I mean, I'm familiar with the case. I just would have thought that had been done quite some time ago.
I agree, Judge.
State agrees, stipulate that I can make the decision based on the 2 previously filed evaluations.
Yes, Your Honor.
Again, I'm familiar with Mr. Flanagan. And I'm sure I've reviewed those quite some time ago, but it was before I was even in the division. Based on that, I'll find that he's incompetent and unrestorable. My concern is there's been more allegations, new offenses.
It's my understanding, Judge, that those misdemeanor cases have already been dropped because he's incompetent and unrestorable.
I mean, to what end? I mean, they're all related to the same thing.
State's option, Judge, is to file a civil proceeding.
My understanding, because I also handled the injunction case that kind of started a lot of this, that is just repeated going back to the same places and bothering the same people or same demographics of people. So yeah, at some point, something has to be done. Mr. Flanagan, you understand you can't go back over to those stores.
I'm sorry, sir. What?
You
where can
understand
I-
you can't go back over to the Winn-Dixie or the ice cream shop or any of those places. You've been trespassed, you've been given an injunction. You
No,
understand?
I'm sorry. I didn't understand that, sir. I'm sorry. Okay, so I'm not to return to the Publix or where else, sir?
I think it's the Winn-Dixie.
Dixie.
Can I be is there an area that I have to totally avoid, sir?
I would avoid that entire plaza of stores because that's where every one of these arrests have come out of. And I've sat here in injunction court and listened to the people and what they feel about you going anywhere near them. Stay away.
Yes, sir. I will do my best to stay away, sir. Yes,
You're not
sir.
going to do your best. You're not going to do it. Okay?
I'm sorry. I didn't mean to say it that
Well, I just want to make sure we're clear.
It's very clear. I will not go near that area. Now, which area is it? May I have a map?
Well, I'll let you talk to Mr. Russell about it some more, but I mean, this has been repeated for 2 years now. And the last allegation, which has been dismissed, involved it being teenage girls. So
I do not.
I'm not asking for a response, Mr. Flanagan, but it's concerning.
Sir, I do not bother young ladies.
Okay. I'm going to talk to you in the back, okay? They're going to put you back there. I'll go talk to them.
I don't have anything else I can do, so look.
Okay.
It's on the state if they want to pursue something. I just.
Well, what are we going to do? Status, or is the state dropping it?
Your Honor, the state is going to dismiss 23 CF 2730.
One in the back.
I don't know what we do, but I mean, I don't have jurisdiction to do anything else. So, thank you, Mr. Flanagan.
Back there.
Okay, Judge. Thank you, sir.
Judge, this is Jessica Thicket. She's number 28 on your docket. I'm going to enter a plea of not guilty on her behalf, request 15 days arraignment motions and trial by jury. I did draft up a bond motion earlier, and I've got my secretary looking to get a date on that. And these are materials. I'm going to send you a letter.
This is the VOP, and then the new law violation is in.
The bond motion's just on the VOP, Judge.
You haven't filed it yet.
I clicked to accept it while I was in court today, and so it may not have made it through the clerk's process yet.
Oh, if you did it today, it's definitely not there. So she has a county court arraignment on April 22nd, felony plea on May 8th for the new 25 CF 652. This one. Where do you want to put them?
Judge, I'll like to, if you want to have.
Are you representing her in the CF case?
Yes. As far as I know, I'm representing on everything except, you mentioned a misdemeanor.
There's a misdemeanor, but the new felony case hasn't been filed on because it's like a week old, so. Why don't we put them both on that May 8th at 1:30? That way they can all kind of ride together once a plea of not guilty has been put in on that date. I just can't plea to a case that hasn't been filed yet because it's brand new. All right, May 8th at 1:30.
It will probably get scheduled for that morning. Okay? All right, go ahead, that's for you.
Just for reference, if it matters to y'all, there's a chance I may be getting someone to fill in on May 8th. It's just arraignments, I think, at this point.
Yes, sir.
I've got a-
Judge, this is Jonathan Eisen. He's here on a return from Florida State Hospital. I went out to the jail and met with them. I believe it was yesterday morning. It might have been the day before. Judge, I can't agree with the hospital's determination. I've done an authorization already to have Dr. Zeman appointed to do another evaluation on him. If he was competent when they sent him over, he's now decompensated.
That evaluation was from a month ago. What would you like to put it on?
Let's set him on a, Judge, he's got about the 5 years in, so I don't want to drag him out too long, because I'm going to have to file another motion. Hopefully I can get Dr. Zeman to rush him and just give me a miscellaneous date.
I have one until May 29th.
Well, if I can get an answer, we can maybe bring him in on Thursday.
All right, put it on May 29th at 2 o'clock. If you get the evaluation sooner, then I'll certainly take a look at it. We can move it up.
And Judge, again, we did that in-house, so you won't be getting a motion in order on it.
I mean, if you get the evaluation back and you want to
Then
move it
file
up for
them.
purposes of
Yes, sir.
a hearing on his competency.
Yes, sir.
All right.
Thank you very much, Judge. All right, I'll be out to see you again, Mr. Eisen, once I learn something, okay?
Back up to the 130 folks that we skipped. Would these are like bring back for potential pleas?
Judge, I believe all mine have been done. May I be excused?
Yes, sir.
Thank you.
That's it.
Your Honor, may I approach?
Yes. All right, Mr. Castleberry, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Barry Wayne Castleberry, Jr., 04/11/2000.
All right, Mr. Castleberry, you're here in 25 CF 423, charged with possession of a controlled substance, third-degree felony, and possession of drug paraphernalia, first-degree misdemeanor. I've been handed a plea and sentencing agreement that calls for you to plead to a lesser on count one to possession of paraphernalia, adjudication and guilt, credit for time served, court costs, and forfeit the paraphernalia. Count two, adjudication and guilt, credit for time served, forfeit the paraphernalia. So basically, it's 2 counts of paraphernalia, credit for time served with some court costs. Is that what you want to do?
Yes, sir.
Did you go over this agreement?
Yes, sir.
Did you understand it?
Yes, ma'am. Yes, sir.
It's okay. Are you satisfied with your lawyer's representation?
Yes.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Any mental health issues or concerns? All right. Do you, has anyone forced you to do this or promised you anything to do it?
No, sir.
Do you understand that you, by entering a plea, you'll be giving up your right to a trial and all the trial rights on page 2 of the agreement you signed?
Yes, sir.
And are you waiving all potential defenses that you have?
Yes, sir.
All right. Do you understand this plea is an adjudication of guilt? Oh, but it's just misdemeanors. But it can lead to your deportation if you're not a U.S. citizen. Do you understand that?
Sure.
Okay. And what is your plea to the 2 counts of paraphernalia?
No contest.
All right. I'm going to accept your no contest to the 2 counts of drug paraphernalia, unless they're included on count 1. On both cases, adjudication and guilt, credit for time served, $270 in court costs, $100 cost of prosecution, $100 VO, or no, not VOP, PD fee, and forfeit the paraphernalia. This is a guideline sentence, it's misdemeanors. All right. You have 30 days to appeal, Mr. Castleberry. Thank you.
Your Honor, we've reached resolution in this matter. May I approach?
Yes, sir. All right, Mr. Pace, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. State your full name and date of birth, please.
Evan Farrell Pace, May 11th, 1984.
All right, Mr. Pace, you're here in 25 CF 256, charged with possession of a controlled substance, third-degree felony. I've been handed a plea and sentencing agreement between you and the state that calls for you to plead to the lesser included offense of possession of paraphernalia, 60 days jail, adjudication of guilt, credit for time served, $270 in court costs, $100 cost of defense, and forfeit the paraphernalia. Is that what you want to do today?
Yes, sir.
All right, did you go over this with your attorney?
Sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice?
Yes, sir.
Are you under the influence of anything?
No, sir.
Do you have any mental health issues or
No, sir.
concerns? Did anyone promise you anything or threaten you in any way to get you to take this plea?
No, sir.
You understand by entering the plea, you'd be giving up your right to a trial and all the trial rights which are listed on page 2 of the agreement you signed?
Yes, sir.
You understand you're waiving all potential defenses?
Yes, sir.
You understand if you're not a U.S. citizen, this could lead to your deportation?
Yes.
Okay. And what is your plea, state's agreement to the 60 days?
It is, Your Honor.
Okay, and what is your plea to the possession of paraphernalia, Mr. Pace?
No contest.
All right, I'll accept your no contest to the lesser included of possession of drug paraphernalia, 60 days county jail, adjudication of guilt, time served, $270 court costs, $100 cost of defense, forfeit the paraphernalia.
Sure.
Thank you, Mr.
Thank you, Your Honor.
Pace. You've got 30 days to appeal.
Your Honor, this is Mr. Dustin Strahan. Just something briefly I'd like to address with the court. I don't believe there's a way for the court to impose a withhold adjudication, given it's going to be a 30-day sentence. That's the agreement that the state and Mr. Strahan and I have reached. Is that correct, or is there any way to do a withhold of adjudication?
I'm not familiar. Usually, if it's a jail sentence, it's got to be as a condition of probation.
Well, Your Honor, I've gone over that with him then.
I think Mr. Russell might be running up after you. Wait, who did? Castleberry? Yeah, I think so. He seemed like a little slow on responding. Like I started to get a little worried about it, but I think he understood. He just.
Okay, Your Honor, so Mr. Russell, a little bit cleverer than I am. I'm going to add this to the plea agreement, but we're going to do a 30-day probationary sentence, so with 30 days in the county jail as a special condition of that probation. Probation terminated upon completion of the jail sentence. And with that, we'd be able to do the withhold of adjudication. So I'm going to add that to the plea agreement real quick, and I'll have Mr. Strahan sign it.
Thank you.
And Your Honor, while he's finishing that up, if I can just say for the court, we don't have a hard copy of the score sheet, and Stack is not working right now, so I can't print one. Is it all right? I don't want to keep him in jail
That gets off
any
at
longer.
5 o'clock.
What's that, Your Honor?
Apparently today it did, yeah, and we lost internet connection and everything else.
I just don't want to keep the defendant any longer, so is it all right if we turn it into